Good afternoon, colleagues. I think we're ready to go. Joy, ready? It says we're live and we're streaming, so I'm gonna look insane just sitting here doing nothing. I'm gonna go ahead and pretend that we're streaming. It looks like it. Outstanding. Good afternoon, colleagues. Here it's January 23rd. We have 3 bill hearings to go forward today. We have basically from House Bill 250, House Bill 254, and House Bill 246. We will go in that order. They are all departmental bills with a shocking number of people to testify. So I would remind everybody in the audience, you're being timed. We have the timer. Good. And please wrap it up when your time is done. Also, as I've stated earlier, I'll continue to state the number of witnesses you have does not always help your cause, especially if people are being repetitious. Sometimes the best thing you can say is "me too." I understand many people have traveled near and far to testify, so that's a risk that you'll take. But I know my colleagues, after a while, everybody's attention span may wane. So I would ask you not to repeat what other people have said. Be brief as you can. That's appreciated, and I believe you get extra points for the brevity. So let's start with our first bill, House Bill 250. And if you have a panel, you can bring it up, sir.
Distinguished committee members, my name is Tony Salazar, Commissioner of Financial Regulation. I want to thank the chair for introducing HB 250, which I'm here to present. Financial service providers today all rely on what we call third-party service providers, or what I'll call TSPs, for a range of services, such as processing their lending and deposit-taking activities, providing physical and technological security solutions, building, operating mobile applications, and other activities. While the use of these third-party service providers helps financial service providers and provides them with many benefits, it also multiplies the risks that these financial service providers and their products pose to consumers and the financial system. The Office of Financial Regulation, or OFR, currently lacks the authority to examine these TSPs. The lack of authority to do so leaves the OFR at a disadvantage to other state and federal regulators, and it limits its ability to investigate or join other states and federal regulators who may be investigating areas that pose risks to institutions operating in Maryland. OFR underwent a reaccreditation examination in 2022, and that examination noted the office's lack of authority, and it recommended that we acquire that authority, which is what this bill does. So it seeks to give the authority to examine the third-party service providers, not only of depository institutions, but also of other financial service providers licensed in the state of Maryland. Regulators in 37 states currently have the ability to examine bank and/or credit union third-party service providers. So having that ability to examine the TSPs provides our office with the ability to gain insight into the operation of these critical service providers and enhances our ability to ensure the safety and soundness of those offering financial services to Marylanders. Of course, it also allows, and this is very important, OFR to receive the examinations that are done of such service providers by other state and federal regulators. We expect no fiscal impact from this legislation, as we expect to rely primarily upon our existing staff and the work of other state and federal regulators to handle this new authority. With that, I request a favorable committee report, and I'm happy to answer any questions or provide additional information as the committee may require.
Thank you, Mr. Salazar. Delegate Chi.
Thank you, Mr. Chair. Thank you, Mr. Salazar. Can you give an example of what you're referring to, third-party service providers, financial services? Are you talking about like Western Unions and check cashers? Kind of?
Potentially, sure, but it would be perhaps the most commonly known would be of a bank or a credit union. They hire a company like Jack Henry or Fiserv to operate their internal systems, right? So they hire these processing companies to handle loans, deposits, things like that.
Are you is your department not regulating them under one roof?
So our office does not have authority to examine them. They're typically not regulated, correct, by our office. We regulate the bank, and the bank is responsible for handling its contractors, and these would be contractors to the bank. But we can't go in and, for example, examine whether or not their IT solutions, their corporate governance solutions and things are all up to snuff. We're relying on the bank to do that. And as I said, 37 other states have the ability to go directly into those service providers, as do the federal agencies.
Thank you.
We have Amy Hennon and Bob Yeager. I believe they're from your office as well.
They are.
Did you guys wish to testify or just here to support?
We're here to answer questions if there are any that we need to, but other than that, we're not.
I see a question from Delegate Weigel.
Yes. Thank you, Mr. Chairman. I heard you say there would be no additional cost to your department, but the legislation authorizes you to collect a fee. Do you anticipate a fee being charged?
So we, at present, and would under this bill, whenever we go into examine, charge a fee related to the cost of our examiners. In this case, what we want to do is obtain the authority to do the examination, primarily because other state and federal regulators will not share their exams with a state that doesn't have the ability to do the examination itself. So we don't plan on standing up a new examination authority or program. What we intend to do is rely on the work that's being done by the other states. Should this situation arise where we feel the need to go in and investigate, we would charge a fee based on what it cost us for our labor charges.
And what do you anticipate that fee might be?
Off the top of my head right now, it varies. I'm not sure what we charge on the depository side, $300 to $500, I think, something like that, depending on the hourly rate for the examiner.
Okay, thank you.
Thank you, Mr. Chairman. I just have a clarifying question. I'm looking online and it says that Bob Yeager from OFR has favorable with the amendment. So I'm trying to understand, is that amendment been addressed or what, what would you like to change to your bill? Oh, okay.
Seeing no further questions. I apologize. Delegate Aaron's.
Thank you, Mr. Chair. Just, you mentioned that the banks are currently doing this now. So they're responsible. Is that right?
Well,
Okay, is there a
So
liability?
the banks are responsible for monitoring the activity of their service providers.
Okay, is there a liability to the banks on this?
Well, other than if we go in to do an examination and the service provider doesn't pay the hourly rate that we charge, then the bank would be responsible for that fee. Or the credit union or the mortgage company, whatever company hires that institution could be responsible for that
And
fee.
nobody's monitoring them currently then.
So on the bank and credit union front, the federal regulators and the 37 other states have the ability to go in and do examinations, and they do. Typically, the FDIC does it of the large service providers.
But in Maryland, that's not happening, you're saying, and you want that to happen.
They are, so for example, the large service providers to the banks provide services to hundreds of institutions, some of which are in Maryland. So if the federal authorities go in and investigate that company, they have certain findings that would apply to all the banks that company services, but we wouldn't know that because they don't share that with us.
And by us knowing it, what will you do with that information?
Well,
Versus this, somebody else who's responsible currently?
it all depends on what we find out and what the severity is, right? If it's something that affects Maryland itself, we would take action on that.
Okay, thank you. Thank you. Mr. Chair.
Seeing no further questions. I believe we have one other witness. Robert Hinton.
Thank you, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Bankers Association. We've spent a fair amount of time over the last 2 weeks in discussions with the Commissioner's office about this bill. As he said, this, a bill that deals with this legislation that deals with this area is in effect in 37 other states. I've looked at a bunch of those state statutes. This particular bill is very similar to the statute that's on the books in the state of Texas, for example. We've have a couple tweaks. We've been in discussions with the Commissioner's office. I think we're 99% of the way there, and some clarifying language on some of these points. And hopefully we'll be back to the committee with, I would say, within the next week with a set of amendments that are fine with, that are the Bankers Association would like, and that the Commissioner's office will be fine with. So I really am totally confident that that's what will happen. So with those amendments, we'd be happy to, we would support the bill.
Could you briefly describe the amendments that we're discussing
So
here?
the bill has three provisions in it that we've been working on with the Commissioner. One provision is that the bill currently states that the Commissioner can collect a fee from either the financial institution or the third party service provider. What we've asked the Commissioner to do, and I think he's amenable to, is to say that if the third party service provider doesn't pay the examination fee within 60 days, then the bank will pay it. And I think he's indicated to me that he's fine with that. That's one change. We didn't, we thought, he's examining the third party service provider, not us. And so we wanted him to at least go to them and say, pay us. And I understand this. I don't think it will be a problem for them or for us. There's also a provision in the bill on page 3 in line 16 that says that he may accept the results of an examination of a federal supervisory agency or responsible supervisory agency of another state as the results under this section if the examination has been conducted within the preceding 24 months. Well, we don't think that, since it's optional for him to decide whether he wants to accept it or not, we're fine with that. We just don't think he should be limited to it happen 24 months. Within 24 months, suppose it happened within 26 months. If he thinks it's valid, he thinks it makes sense, he thinks that he can accept those findings, that's fine with us. So we've offered that as an amendment to him. Final amendment, we're just looking to kind of clarify is the language on page, pardon me, I believe on page 2 of the bill that says that the Commissioner, line 16, the Commissioner may accept the results. No, I'm sorry, that's not it. The definition of what constitutes a third party service provider, to make sure that that's an appropriate definition, and we're working on that with him. And once again, I'm totally confident that we'll reach an agreement on that as well, and we'll be able to come back and say we've signed off on this and we're fine with it.
Seeing no questions, thank you, Mr. Renton. Oh. Delegate Queen.
Thank you, Mr. Chairman. Just clarification on the second issue you had with the OFR concerning this time limit of a prior federal examination. Are you saying, I think those happen like every 2 years or something like that? How often do they happen around about? Like every 2 years. So are you saying as long as it falls within that 2-year time period that he should accept it, or are you just saying don't give me a date at all?
No, I'm saying he can accept it. I just don't think it to have an arbitrary two-year period. If the report of the state of Virginia was issued 26 months ago, but it's a good report, it's a solid report, and he wants to accept it, we think he should have that discretion. The way the bill is written right now, it's within his discretion whether to accept it at all. So I don't know why we would have to, he decides he doesn't want to accept it, it's not valid, he doesn't have to at all. So we're fine with that. We think he should have the discretion. We just don't think we should pick an arbitrary date that if it's the report of another state is.
So if it was if he says, I don't want it, if it was within the 2 years, you don't care, just long as he just says he doesn't want it, he doesn't want it. That's fine.
Yeah, I think he's okay with that. Just, he's got the total discretion anyway,
Okay,
whether to use it or not. And let me just say, if I could, that from in the state of Maryland, our large banks are national banks.
all right.
They're not regulated under Maryland law by the commissioner.
Mhm.
This affects our small community banks, the Harbor Bank in Baltimore, for example. Other small banks down on the Eastern Shore or in Charles County, small independent banks that pretty much only do business in the state of Maryland. That's who we've been working on with this bill because they're the ones that will be impacted. And with the three issues I've outlined today, those smaller banks, community banks that serve your constituents are okay with the bill if we work those three issues out.
Sounds good. The last one in this bit, isn't the definition of third-party provider already somewhere in our statute? Why is that some kind
I
of
don't
issue?
believe it is. You'd have to ask the
Really?
commissioner. I've
Okay.
never, and this was all news to me. I didn't know this was in the other states. So didn't know it was an issue at all.
No other questions. I believe this concludes the hearing on Bill 250. Thank you, Bob.
Thank you, sir.
Next bill is House Bill 254. I believe Mr. Salazar, is that you again?
Yes, it is.
Did you want Amy to come up with you, or are you good? She said no.
I'm only here for questions of people.
Just for questions.
Okay, we'll just start out with two of you, then we'll call the panelists. Go ahead, sir.
Thank you. Good afternoon, Chair Wilson, Vice Chair Crosby, distinguished committee members. For the record, I'm Tony Salazar, Commissioner of Financial Regulation. And again, I want to thank the chair for introducing HB 254, which I'm here to present. In keeping with our office's mission, HB 254 affirms protections for Maryland consumers from deceptive and predatory lenders that seek to avoid the state's consumer lending interest rate caps and licensing requirements. The bill prohibits the use of subterfuge or pretense to evade the state's licensing requirements and its interest rate caps by identifying and outlining certain practices that have been used to claim exemption from Maryland's consumer protection laws. Similar to legislation that's been enacted in Maine and New Mexico, this bill confirms that non-bank lenders cannot use non-Maryland banks as fronts to charge excessive and illegal interest rates. In recent years, non-bank financial technology companies have partnered with out-of-state Maryland banks to offer Maryland consumer loans at rates that exceed Maryland's lending limits. These partnerships allow the non-bank lenders to claim that they are not the true lender, and therefore they're not subject to our state's consumer lending and licensing laws. Untangling these arrangements is complicated and time-consuming. So this bill establishes criteria to identify what's known as the true lender in such transactions based on the economic substance of the transaction, not the form that's selected. So if the fintech is deemed to be the true lender, that loan must comply with Maryland's laws on interest rates. The lender must be licensed. If the true lender is deemed to be that non-Maryland out-of-state bank, then federal interest rate exportation law applies, and that bank is not required to be licensed, and it's permitted to charge the interest rate consistent with its own state's limits. So this bill will provide guidance to the industry, it'll provide guidance to the courts that hear the cases, and it'll help my office better enforce the state's consumer financial protection laws. We anticipate no fiscal impact on the office, and with that, I request a favorable committee report, and I'm happy to answer any questions or provide additional information as the committee may request.
All right, seeing no questions, we'll move on to the first panel.
Thank you.
Marceline White. Lauren Sanders. Donna Edwards. I see Bob Yeager's here as well. This is just for information.
Yeah.
Phil Goldfeder. And we have one virtual that we'll call when this panel is done. May proceed.
Okay. Chairman Wilson and members of the committee, I'm Lauren Saunders, a Maryland resident and Associate Director of the National Consumer Law Center, a nonprofit working for economic justice for vulnerable consumers. We are pleased to support HB 254, which codifies the widely accepted true lender doctrine and stops predatory lenders from charging up to 200% interest in violation of Maryland law. Lenders like Opportunity Financial, Elevate Credit, Easy Pay Finance, and American First Finance make online or mobile-based loans at 100 to 200% APR, using rent-a-bank schemes to claim that their loans are bank loans exempt from the laws of states like Maryland. Maryland has brought enforcement actions against rent-a-bank lenders, but enforcement is time-consuming, and some lenders have still offered loans in Maryland and may still be doing so. The true lender doctrine applies 200 years of anti-evasion law to look behind the bank's name on loan documents to discover that the true lender is a non-bank lender subject to state law. The doctrine often focuses on which party has the predominant economic interest in the loan, as the bank may hold as little as 4% interest in the loans. But that is not the sole factor. Anti-evasion efforts require looking at the totality of the circumstances because usury evasions are infinitely varied. The true lender doctrine has been recognized in numerous court decisions by the FDIC and by Congress, and many states have codified the doctrine, including 5 states since 2021. The statutes have been effective as high-cost lenders have left states after the bills have been adopted. Maryland does not need 200% APR loans. I urge you to support HB 254, which will ensure that Maryland's strong anti-predatory lending laws cannot be evaded by rent-a-bank schemes. Thank you.
Good afternoon, Chair, members of the committee. My name is Marceline White. I'm the Executive Director of Economic Action Maryland. Economic Action Maryland works for economic rights and equity through direct service, research, and advocacy. We have 12,000 members across the state, and we work on direct services today and systemic change tomorrow. I'm happy to be here in support of HB 254, and I want to thank the Commissioner for bringing this bill. As you know, I've been here in this chamber a number of times to stop predatory loans. And this committee in particular has been taking a leadership role in closing loopholes, ending high-cost, unsustainable lending. You've done so in 2001, 2010, and then again in 2017. Maryland has had a long and storied history of protecting our working families from high-cost loans. This is another in a long line of protections and builds on the legacy of closing these loopholes to keep families safe from unsustainable lending. This new scheme is a rent-a-bank scheme where a predatory actor uses the facade of a bank to import high-cost loans to Maryland consumers, loans charging up to between 99% and 189%. And for those reasons, we've already said for more than 4 decades, these are not the kinds of loans we want in Maryland. HB 254 closes that loophole and allows the commissioner to assert its authority and keep loans sustainable and affordable for Maryland families. For all of these reasons, we urge you to support HB 254, and I ask for a favorable report. Thank you.
Excellent use of your time. Next.
Thank you, Chairman. I think I'll start by saying that not all fintech is created equal. Not all bank fintech partnerships are created equal. And while it's sometimes simple to cast them all in one big shadow, I think what that does is a disservice to the residents of Maryland who are looking for access to fair, responsible credit. My name is Phil Goldfeder. I'm a former state legislator from the state of New York, and I continue my public service today as the CEO of the American FinTech Council. Both as CEO of AFC and as a state legislator, I believe in developing sound public policy that ensures responsible actors can operate for the benefit of consumers and discourages irresponsible actors from operating in an industry. During my time in New York State Assembly, I crafted the legislation to hold insurance companies accountable, to hold banks accountable, to ensure the protection of my constituents without hindering their access to credit. While I respect the bill's sponsor and intent to find creative ways to curtail unwanted practices, as you've heard, I think that the idea of true lender as defined does not lay out a good enough test to ensure that we are differentiating those good actors and those who are not. In practice, painting with a broad regulatory brush will only serve to stymie responsible actors. The use of the test established in HB 254 to determine the true lender of a loan will limit the ability for responsible bank and fintechs to operate in Maryland, and in turn, limit the availability of access to credit for thousands of Marylanders today. As I noted, I strongly believe in developing sound public policy, and based on my experience, I believe there's a viable path to doing so on the true lender issue. The Illinois Predatory Loan Prevention Act, which sought to accomplish many of the same goals as this bill does, established an exemption to its true lender test for loans originated below 36%. As noted in a recent study by the Woodstock Institute, an Illinois-based consumer group, this path stopped predatory lenders from operating in their state, while also allowing responsible lenders the opportunity to continue serving Illinois residents who needed help the most. At the end of the day, we're here to serve the people that we represent, and ultimately, by cutting off access to responsible products is only going to force them into going to.
Well, thanks, sir. And I think as everybody's recognized that you were one of the unfavorables. Apologize for mixing with the group. So
That's okay. We get along just great.
There you go. Go ahead, sir.
Mr. Chair, members of the committee, my name is Brian Wyville, and I'm here on behalf of President Donna Edwards and the Maryland State and DC AFL-CIO. We are here to testify today in support of the True Lender Act because we believe that fundamentally Maryland as a state has committed to strong consumer lending protections, and you'll see in our testimony now and for subsequent bills that the consistent theme here is we already fought for these consumer lending protections, and it is our responsibility to make sure that these loopholes are plugged so that we do not have to worry about working people who, unfortunately, due to low pay and infrequent pay, occasionally have to rely on many of these products to make their ends meet, but that we make sure that these workers that do use these products are well protected by the existing consumer protections that the Maryland General Assembly has over years put in place. So I will yield the remainder of my time and ask for a favorable report on HB 254.
Thank you, Mr. Weibel. I'm sure you're
My long lost cousin.
proud. And I'll say, now again, they had you sign up here as Donna Edwards. Is this?
I apologize. That was an entirely unforced error on my part. I signed up for both as Donna Edwards when I was supposed to use the Brian Wyville account.
I wanted to make sure, just because we tend to not let people sub in for other people last minute unless
Apologies.
it's a true emergency. But obviously, you've handled it. I believe we have one more to go. We have a virtual, right? Oh, well, Delegate Queen. No, he's there. Might as well go get him.
Am I the unfavorable? I'm unfavorable on the bill.
You were the unfavorable testimony. Sorry. You're a favorable person. Thank you, Mr. Chair. So I wanted to understand some of your concerns because as I understood, the sponsor was saying that if the fintech is outside of the Maryland base, they would follow federal guidelines. And then if they were within Maryland, they would follow our guidelines, which is that 36%, well, whatever that we have for Maryland banks. I don't understand why that would make someone not provide services because they could just be considered outside and follow the federal laws. We can't change the federal laws. They would have to follow that. So what would be the issue?
So most responsible online lenders are partnering with state chartered banks. And state chartered banks are bound by the usury laws of their home state.
Correct.
And so depending on where those banks are chartered will ultimately determine what the rates they're allowed to offer. And I think I would agree with most of what was said before me, even though I'm opposed to the bill, simply because we're also opposed to predatory lending.
Right.
A lot of all of the members of our association are lending at responsible, reasonable rates that are providing reasonable alternatives. I mean, the challenge is access to credit in Maryland.
Mm-hmm.
And sadly, as we all know, traditional banks are simply not servicing communities, particularly in rural minority communities all across the country, not just here in Maryland, but Maryland is no different than most other states.
Sure.
A lot of these lenders stepped up post the Great Recession, where you saw the de-risking from the biggest banks in the country, who basically said, we can't do it anymore. We're not going to waste our time in local communities. That's where fintech came from. The idea of innovating is about creating that access. The regulatory structure needs to meet that, right? And I think there's ways to work together to say, you don't have to throw away all of it and you don't have to accept all of it, right? We want to work together like we did, and you take a look like Illinois and New Mexico and other states across the country. We're looking for ways to find the right balance to ensure, especially as the Fed continues to raise interest rates, you can have great credit today and still not be able to get a loan below 12%. So can you imagine if you're a 720 or a 680, you're literally going to be shut out of the system.
I guess the concern though, as I, that I see it, that 36% is a big number to, I mean, your fintechs can't work within 36% as
They
a.
can. No, that's the point. Our
Okay.
membership agrees.
So you will
that-
stay here in Maryland then?
What's that?
Your fintechs will stay at working with the charter banks in Maryland, because 36% is a lot of leverage.
Correct. I mean, again, all of our members are beholden, are willing to stay below, have committed to staying at 36% and below. I think the challenge here is that it creates more confusion than it's trying to clarify, right? The concept of.
And so is there a state legislation you think that's better than what we're proposing?
Absolutely. I think we're striking some of the right chords, whether
So
it's
it was
totality-
Illinois, and who was better?
Illinois, New Mexico.
And New Mexico?
Yeah, as well as a few others. I think predominant economic interest creates some challenges. I don't think it's as clear as established law.
Okay.
So I think there are other ideas. Thank you.
Delegate Adams.
Thank you, Mr. Chair, and also to the unfavorable testimony. So
I may start taking it personally.
I actually probably support your position, but I'm.
In that case, bring it on.
Interest rates are normally an expression of market conditions and the acceptance of risk. Could you just talk for a minute about what your product is and why interest rates might be higher than a standard product? I mean, are you going after markets because this is a lender of last resort, or is there a flexibility that your industry offers that they can't find in the traditional banking system? So I just trying to understand what it is that you are meeting in the market.
So as I mentioned, I represent an organization called the American FinTech Council, which is comprised of a number of fintech companies that are using innovation and technology to offer additional financial products. In the case here, we represent companies like Avant or Prosper or Upgrade, Upstart, Lending Club, who are providing, who stepped in post-recession to create opportunities for families to access financial services. I mean, today, and I think about my kids, wouldn't know what the inside of a bank looked like. They do all their banking or all their needs on their phones. And so these are the technology companies that are providing that access. There are those who seek to take advantage of families in their biggest time of need. I represented a district in the aftermath of Hurricane Sandy, and I don't have to tell you how many predatory lenders stepped in to, sort of quote unquote, help families and ultimately put them in deeper debt. What my members are doing are providing fair, reasonable, and safe alternatives to these predatory loans, and they're doing it at interest rates below 36%. As you mentioned, as interest rates rise, if you have you go back 2 years ago, if you had a great credit score, you can get a consumer loan for 4% or 5%. Today, you can have a great credit score and you can't get a loan for less than 12 or 13%. And now think about when you get hit with that emergency. Right? It's easy to say do away with these programs, but you get hit with that emergency, the doctor's bill, the car bill, whatever comes up that you get hit with, and all of a sudden you need access to financial services. Unfortunately, you can't just walk into a branch and get an unsecured consumer loan. And so what are you left with? You're left with the products that are out there. So maybe you can get a credit card. And as we all know, you don't know what the terms are. You don't know what the conditions are. All you know is that if you miss a payment by 5 minutes, you're getting hit with a $30 fee. And yet there are these consumer finance companies who are providing fair, safe, transparent products to the consumers where they are. I think for consumers of Maryland, you take off the safe products, and what are you left with? You're going to be left with those unregulated companies who don't care, right? Who are going to look for the loop around. Members of the American FinTech Council embrace the regulatory structure. They embrace the rules of the road. And they want to work with you to create a system that provides access to credit without limiting consumer protection.
Mm-hmm. And so the only thing that you're asking for in this hearing is some changes in the legislation that relates to what constitutes a true lender. That might be the basis for the entire bill.
Correct.
So I'm trying to figure out where you find
your position, which would be I accept the principle that there are predatory lenders, yet we're not one of them, but we feel like the bill brings us in.
Correct.
I'm trying to find that spot that your testimony is driving at.
And so I think there are other mechanisms which to use, whether it's totality of circumstance, which I think is also touched upon in the bill. I think the idea of predominant economic interest is something that has been debated for a long time, is not a good test of who is responsible or who is making the loan. I think ultimately there are good bank fintech partnerships, banks that partner with fintech companies to offer good products, and there are those that don't. And there are many mechanisms in which to use to make that determination, as we have in other states.
Well, look, thank you very much.
Thank you, Mr. Chair. I just want to clarify, it's my understanding that this bill, maybe the question is is it Lauren with the National Group? This bill doesn't eliminate the fintech products that we're talking about. This bill regulates those products. Is that your understanding? Okay. And my follow-up question is, is it Goldfarb? Sorry. Goldfeder, I'm sorry. Mentioned bills in other states. Illinois was one of them. Are you familiar with those and how they compare to what we have here? And are those models that we should be looking at, or are there concerns about how those played out?
This bill is virtually identical to those laws. The only difference is that Illinois and New Mexico allow loans up to 36%, no matter how big the loan. Maryland has made the judgment that interest rates should be a bit lower. As Delegate Queen noted, 36 is a very high rate, and many of Mr. Goldfeder's members make very large loans, $10,000, $20,000, $30,000 loans. So if they stay within Maryland's limits, and if it is really not a bank loan, it is really a non-bank loan that is subject to state law, then it absolutely would be allowed here, but it has to stay within Maryland limits. A 36% rate on a $30,000 loan is an exorbitant rate, and we can have the debate about whether Maryland's rates, limits should be changed, but the standard is, almost word for word identical to the Illinois and New Mexico laws.
So the broader regulatory structure is the same, and then this sets it up so it's equivalent to what we've established in Maryland as our expectations of what's acceptable for our constituents. Is that right?
That's right. It really just, enforces the law that if you are not a bank and if you don't meet the true lender test, then you have to comply with the laws that govern non-bank lending in Maryland.
Thank you.
I believe there are no further questions. We still have a virtual Whitney Barkley Denny. You can go ahead, ma'am, if you can hear me.
I sure can. Can you hear me?
Yes, ma'am, go ahead.
Wonderful. Okay, let me just pull my document back up here. So my name is Whitney Barkley Denny, and I am a senior policy counsel and deputy state director at the Center for Responsible Lending. And I'm here to testify. Uh-oh. Can you hear me?
We can hear you just fine, ma'am. Can you hear us? Technology at its best. How about now, ma'am? Can you hear us? Nope. Well. Ma'am, can you hear anything?
Mr. Chair, can you hear me? Okay, good. I think there was a lag time, maybe. All right. Yes, can you hear me?
You're good. Yes, we can hear you.
Okay. All right.
That's me doing it. Go ahead and speak. We can hear you.
Okay. My name is Whitney Barkley Denny, and I'm senior policy counsel at the Deputy Director of State Policy and Center for Responsible Lending. I'm here to testify in support of HB 0254, the True Lender Act. As my friend Marceline testified, Maryland, I can't.
We can hear you.
I'm speaking.
That's fine. I know. We can hear you. Keep going. Keep going. Oh, boy.
Has a long history of prioritizing consumer protections and its laws, regulations, and its Office of the Attorney General. That's one reason why Rent-A-Bank is so odious. Rent-A-Bank allow predatory lenders to ignore state laws and legislative intent by partnering with state chartered banks in places like Utah and Kentucky.
She froze or?
Try that. I need something darker. Right.
But we can't, there's no chance you can see this. This is hilarious. Dude.
And they do so brazenly. In a 2019 call with investors after California passed a 36% rate cap, representatives from Inova said, "We expect to be able to continue to serve California consumers via bank sponsors that are not subject to the state."
You're good. We can hear you. It don't matter. All right.
Oh, turn the streaming on. She's on.
Ma'am, are you streaming as well? Yeah, so you're seeing the delay versus just testifying. Take off the streaming, please. There we go. Please continue, try to wrap it up. I know we have your testimony, please.
I'm trying to figure it out.
You just stop your streaming and and stay on Zoom.
Okay, I think this is it. If you can pardon me, I apologize for that, and I will go through this in the 2 minutes as quickly as I can. Mr. Chairman Wilson, Vice Chairman Crosby, and members of this committee, thank you for the opportunity to testify today. My name is Whitney Barkley Denny, and I'm Senior Policy Counsel and Deputy Director of State Policy at the Center for Responsible Lending. I'm here to testify in support of HB 0254, the True Lender Act. As my friend Marceline testified, Maryland has a long history of prioritizing consumer protection in its laws, regulations, and its Office of the Attorney General. That's one reason why Rent-A-Bank is so odious. Rent-A-Bank schemes allow predatory lenders to ignore state laws and legislative intent by partnering with state chartered banks in places like Utah and Kentucky. And they do so brazenly. In a 2019 call with investors after California passed a 36% rate cap, representatives of Inova said, "We expect to be able to continue to serve California consumers via bank sponsors and are not subject to the same proposed state level rate limitations." It should come as no surprise that Inova also has a history of ignoring Maryland law, as one consumer learned in 2022. And this is cited in my written testimony as well. In a complaint to the CFPB, an Inova customer describes taking out a $1,500 loan from the company. Imagine his shock when he learned that he had paid back $4,000 over the years. This despite Maryland capping APRs on loans of $2,000 at 30%. If Inova had followed the law, the borrower would have paid back only about $500 in interest. Another complaint by a Marylander is even more concerning because the borrower took out nearly 200% loan from American First in order to get her car repaired. That borrower is also on the hook for $4,000 on a $1,300 loan. Again, because of Rent-A-Bank, she was able to take out a loan while checking out of a Maryland business on a Baltimore street, despite laws prohibiting gouging customers at this rate. So with this bill, the True Lender Act, you have the ability to stop this brazen violation of Maryland laws by out-of-state operators, protect vulnerable consumers, and enforce the laws that have been crafted by some of the very members of this committee. I urge you to recommend the passage of HB 0254. Thank you, and I apologize for all of the technical difficulties. I was laughing on my end as well.
Thank you very much, ma'am. Seeing no questions, I believe that concludes this matter. Thank you, guys. We'll next be hearing House Bill 246. I believe we have Antonio Salazar, Secretary Roquez. Yeah, what was that? Wow, that was not, is it spelled differently? Okay. There you go. Secretary Roque and Secretary Wu. We have some distinguished folks for our first panel here. So Salazar, go ahead and take it away.
I will defer to Secretary Wu to do the introduction. Thank you.
Good afternoon, Chair Wilson, Vice Chair Crosby, and members of the committee. For the record, I am Portia Wu, Secretary of Labor, and I'm here to introduce HB 246, which is our departmental bill on earned wage access. This bill would ensure pre-payday cash advances continue to be covered by Maryland's consumer protection laws. This is of critical importance to low-wage workers in our state. We all want to expand financial services to low-income workers who have had limited access to banking, but these products must comply with state law. They should not come at high costs that evade Maryland's consumer protections. Workers relying on earned wage access loans are living paycheck to paycheck, getting advances dozens of times a year, and each time facing service fees, expedite fees, and sometimes requests to add a tip, all of which add up to costs that are many times higher than those currently allowed under Maryland law for any other lender. These workers are critical to our economy. They work in retail, delivery, food service, home health care. Many are Black, Latino, or belong to other groups who face barriers to accessing credit. So it's particularly important that they have strong protections so they can keep as much of their hard-earned money as possible. It's therefore no surprise that this legislation is supported by a number of labor, civil rights, and consumer rights groups, and I want to thank them for being here to testify today and submitting their written testimony. I've submitted longer remarks to the committee, but I'd like to emphasize 3 key points. First, the General Assembly has made clear any advance of money with an expectation of repayment is a loan and should be treated as such. There should not be special exemptions, particularly when it comes to products targeted at low-income workers and our most vulnerable. This is not just about the fees being charged. It's also about ensuring products are licensed and that our laws protecting consumers against unfair, deceptive, and abusive practices apply. Second, fees and costs must be transparent. Labor supports the amendment being offered to ensure this is the case, particularly with respect to the tips or gratuities that are often charged. Finally, this bill does not prohibit earned wage access products or providers. It simply makes clear that if a provider offers this service in Maryland to Maryland workers, they need to follow the same rules of the road as every other lender operating in the state. Ensuring our lending laws apply to earned wage access products will keep more dollars in the pockets of hardworking Marylanders. I urge the committee to report favorably on this bill.
Madam Secretary, briefly before we go on to the next panel, it has you down as favorable with amendments. Is that a mistake?
Maybe Commissioner Salazar can answer. I believe we have an amendment on the tip and gratuity issue. In part, it was offered by the Attorney General.
Correct. I was going to make a statement following up on the secretary to discuss the amendment.
Well, that's why I was going to start with you, buddy, but we'll go ahead. You can go now.
I'd rather have my boss give the
Gotcha.
overall positions. Thank you, Chair Wilson.
Thank
Distinguished committee members, for the record, I'm Tony Salazar, Commissioner of Financial Regulation, and I want to follow up on the Secretary's introduction and appreciate that and maybe just put a couple of points in quickly. OFR is Maryland's Consumer Financial Protection Office, and so we've put in HB 246 to affirm protections for Maryland consumers, and it does so in 2 ways. Number one, it outlaws deceptive and predatory lending practices that seek to avoid not only the state's consumer lending interest rate caps, but also the licensing requirements. And secondly, it also creates certainty around products that are known as earned wage access. So let me just say, employers for a long time have offered low wage and hourly workers the opportunity to access a portion of their accrued wages before the end of the payroll cycle. But recently, these products have been grown in popularity and they've been known as earned wage access. So while employers typically offer this service free of charge, recently with the growth of fintech and things, third-party companies have started offering these fees with fees or with other costs. Some charge a flat fee, others, as the Secretary alluded to, charge a tip, and still other companies advance funds and then they use a debit card for which transaction fees are charged. These costs can be difficult for consumers to understand and avoid, particularly since the products don't disclose an interest rate that's being charged. But as the Secretary said, because these products involve an advance of funds by the companies, and these funds seek tips from the consumers and they seek to be repaid, we view them as deceptive and constituting loans that must comply with Maryland's consumer lending laws. Some of these consumers typically seek advances of less than $100, but because the fees and tips are added into this, they're getting an APR of 100% or 400% to receive their earned pay. These rates are far above the maximum rate of 33% that we just heard talked about in the prior bill hearing. So they shouldn't have to pay that type of fee to receive their salary. This legislation codifies longstanding principles that OFR believes apply to these earned wage products. As the secretary said, the bill explicitly treats these products that charge a fee and require repayment as loans. And to the point we made at the beginning, we're offering an amendment developed in conjunction with the Attorney General's Office on Consumer Protection that provides that no one who extends credit under Maryland may request a tip for the privilege of extending that credit. We anticipate no fiscal impact on the office. And with that, I also request a favorable report, and then we'll defer to the secretary.
Yes, ma'am.
Good afternoon. It's lovely to be here with all of you. I'm Carmel Roque. I am Secretary for the Department of Aging, and I am very happy to be here to testify in support of House Bill 246. I'm here because my main concern as the Secretary of Aging is the well-being of older people, their families, and their care providers. Recently, the Department on Aging has started an initiative which we call Longevity Ready Maryland, which basically means being able to enjoy longer lives that are healthy, financially secure, socially connected, and purposeful. And I believe that this bill will help ensure that that is possible. Key elements of our plan include strengthening the direct care workforce, improving the economic well-being of older people, expanding Maryland's workforce by increasing older worker participation. All of these efforts together will catalyze increased economic well-being and will help all Marylanders afford longevity. That is, the longer lives that we are so blessed to live in current times. Bills such as this one provide critical safeguards for the workforce across the full lifespan. Marylanders are not only living longer, but staying active in the workplace longer. As we grow the economy in Maryland, it will be increasingly important for older workers to be employed, to stay employed, and to have the knowledge and resources available to prepare for their after-work life. Approximately 29.5% of the workforce is over the age of 55 in Maryland. Currently, about 11% of low-income workers are age 55 to 64, and approximately 17% of low-income workers are over the age of 65. Together, this nearly a third of the low-income workforce in Maryland is made up of older adults. The older adult workforce is growing, and by 2030, which is 6 years from now, not in some distant future time, there are projected to be 1.2 million workers aged 50 years and older in Maryland. Many critically important caregiving jobs in Maryland are low paying, and these workers are providing the infrastructure for our aging population. Minority women make up a significant portion of the frontline caregiver workforce. They deserve state protection, as do all workers. They deserve to be protected from exploitation and predatory practices. Prioritizing the wages and fair treatment of low-income workers, whether they're older or they are caregivers, is foundational to building a strong workforce and growing our economy. I thank Secretary Wu for the privilege of being able to support this important legislation and for her leadership on this issue. I urge a favorable report.
Thank you.
Chair Wilson, I also have testimony for the department.
Your name?
Bob Yeager.
Oh, you're testifying this time?
Yes.
All right, go ahead.
Okay.
Good afternoon, Chair Wilson, distinguished members, committee members. For the record, I'm Bob Yeager, Assistant Commissioner for Policy at the Office of Financial Regulation. I'd like to provide some history on House Bill 246. Last year, OFR turned its attention to companies providing short-term loan products in Maryland under the name Earned Wage Access. We found in 2023, there were hundreds of companies hundreds of complaints against these companies filed with the Federal Trade Commission by consumers nationwide, with dozens of complaints coming from Marylanders. OFR analyzed the law, and last fall we issued guidance clarifying that these products are considered loans under state law. The companies offering these products are required to be licensed by OFR and comply with the state's lending laws. Because there are several EWA variations, OFR also offered to conduct licensing determinations for any provider who requested one. But to this date, no provider has made that request. Instead, providers have sought to argue why their products should not be treated as a loan. We've met with every provider that's contacted us, and several companies have provided legal arguments, but they cite out-of-state laws and decisions, argue unrelated topics, and ask general questions about how the law applies. In the end, OFR determined that these questions were best answered through our issued guidance and with this proposed legislation. There's currently no Maryland case law exempting EWA products from our lending laws, and no companies provide legal analysis under Maryland law that would change OFR's position, that when you advance money with the expectation of repayment, it is a loan. Finally, OFR firmly supports innovation, especially to expand access to financial resources, especially to help those living paycheck to paycheck. However, EWA providers offer a very old product, a loan against your anticipated paycheck. This bill lets providers continue offering their products to consumers, but it also ensures that Maryland consumers are still protected by Maryland's lending laws. I urge the committee to favorably report on HB 246, and I'm happy to answer any questions.
Thank you. I'd like to start. I just have a few questions. Salazar, you were speaking, well, I just want to go, what was the issue with the tip? Why is no tip such an important thing?
Chair Wilson, when you go to a restaurant and the service person gives you your meal or something, you interact directly with them and you provide them with a tip.
I don't think that's true at all.
Well, sometimes, right?
I'll say about 90% of the time, I get a tip put into what I'm going to pay before I even leave the register. So that's why I want to get to that. And we seem to be fine with paying a tip for a service we have yet to receive.
But, well, that's true, but we're talking theory. So you as an individual expect to pay an individual who has provided you with a service.
Correct.
That's the traditional definition of a tip. That's what we all expect as a tip. In this case, it's a company that is requesting you to provide a tip when it's a company providing you a service. It's not an individual to individual gratuity. It's a fee. Okay. And again, I feel like I'm reeling you in here, so I'm going to keep doing it. Okay.
So when I go to, I don't know, a place that sells salads, because I don't want to mention anybody's name, and I go to the register, I order my salad, and I look down, it says 15, 20, 25, other, and it's somewhere you might be able to find the word no tip. Isn't that a problem too then?
Well, that's it. That's
because it sounds like, I mean, that's the person taking the order. They're not even making my food and they're watching to see what I do. So I'm just saying, do you have a problem? I want to know what your big issue with the tip is. And you know, I'm going to use your words later.
Sure.
So I'm asking you what your big problem with the tip in this specific instance, when everybody in this room has probably paid a tip very similar to this within the last 2 days. If you've ordered food anywhere, they've asked you to pay a tip. The person not preparing your food is asking you to pay a tip. You don't even know where it's going. And you have to actually pay that before you receive the service.
Perhaps this chairman, if I this one, because it's a crossover really between the labor law issues, which I know are confusing to people, and the financial regulation laws. In the situation you're talking about in food service, it is common, and I know it's frustrating and frankly in some ways not transparent to people either there, saying, who is this tip going to? And part of the reason restaurants and other institutions use those tips is because the structure of the minimum wage allows you to take a tip credit and say, okay, I'll use that tip that people are paying, consumers are paying, and pay that to the workers. And therefore that reduces my obligation as an employer to have to make up as much for minimum wage. That's why you see a lot of food service places doing that. So I think there's sort of a bigger question about that practice. And I know a lot of consumers find it very frustrating, and they're not sure who is this going to, unlike when you get an individual server. So we'd be happy to discuss that more and also make sure that workers actually are getting those tips, because I think that's a little confusing to us too sometimes. But separately, in this context, I think it's very clear, you're just interacting with an app. You didn't interact with any individual service person. And what's happening is, but of course, frankly, low-wage workers and all workers, but low-wage workers in particular, are very likely to tip, right? I think the statistics we looked at showed 60 to 70% of people, when offered this option, offer a gratuity. People say pay it forward. They want to help another worker. What they don't realize is it's a service, is an additional service fee going into the coffers of the company. And so that is what we think is fundamentally misleading about that, because people don't understand that's what's happening. And that's why the Attorney General's Consumer Protection Division, who I know will be testifying later, suggested to us, and we agree that frankly, it makes sense, not just with earned wage access, but other financial products, because we're starting to see that creep in. Say, look, if you want to charge other service fees, that's okay, but let's call a spade and tell people what it is.
And I really just want to get to that point. I do hope the Attorney General brings this online with some of our restaurants too, because again, I do disagree. A vast majority of the tips we give out are to people. There are no waitresses. There are no tip credits. They're McDonald's, they're Burger King, they're Cava, they're Grubhub. And we give a tip well before we get any service, and they're not tip employees, they're salad employees. Because I always ask, where does the tip go? And nobody can tell me. So we're tipping a lot of companies right now. That's why I found it interesting with the stance on this specific company, with damn near every restaurant out there taking these very same tips. And they're not even as voluntary, because you have to hunt down the word no tip, and they start at 15%. And there's only 3 options. But I do hope the Department of Labor and the Department of the AGs look into that too, because I would love to hear that position. I want to go to another part. When we're talking about loans, one of the things that we've discussed here is what makes it a loan. And when you have a loan, you have to divulge the APR, correct? That's one of the important things. So my concern is the APR is very dependent upon when that loan is expected to be paid back, and it goes higher in the shorter term, right? If they do a definitive, if I loan you $100 and I say you're going to pay me $3.50 on that loan when you pay it back, it's way higher if you pay me back on Monday than if you pay me back on Friday, right? And I am horrible at math. So my point was, I hope that at some point in our future, we can understand that most people in this room, maybe, I know I'm one of them, couldn't tell you what an APR, I know what the words mean, but I don't know how to apply it to a loan. I just know what looks good and bad because that's what I've been told. Meaning sometimes fees can be just as protective as long as they're upfront about them and they're forthcoming as a standard APR rate. Because again, if I'm charging you, we just talked about this. I'm saying you gonna borrow me, if you're gonna loan $100 or borrow $100 from me, you're gonna give me $100 plus $3.50. Whether you give that back to me on Monday or a month from now, if we were to run the APR, that would be drastically different, wouldn't it? And almost predatory, depending on if you paid me back, how early you paid me back. Fair?
Well, so the APR is intended to be a device that allows people to measure equally different products, right? And so the legislature is set up. Loan products need to be able to, meet that standard so consumers can understand what they're paying, as you mentioned, time and everything else, and compare that with other products that are similar to that. In this case, we believe the law is very clear. The law is clear on the books. The law is clear from the courts that if there is an extension of credit, and in this case, these third-party companies extend their own money to the consumers, they expect payment back, which is why they get the bank account information from the consumers to get the payment back. It's a loan. And then it should be treated the fees and interest should be calculated according to the way all the other ones are calculated. That results in an APR that can be compared. And people generally understand that.
Generally is a very,
Generally.
but I appreciate your honesty. But what I'm saying is because one of the things I've noticed in doing my background research on this specific earned wage access is that a lot of people are using it. So there's that. Then let's go down to the second part. It's really hard to get somewhere else because let's be honest, if the employer was doing it, these companies wouldn't exist. So we have a need out there. And my worry is because we may not update our laws for loans, that these folks are going to be just out because now they have no way of getting it. So we made it very clear there's a need. And I want to make sure that this bill or other bills don't pretend that that need doesn't exist and say just because we've made it to where you can't do it in Maryland, that we have now, you know, taken care of our citizens, because we clearly haven't. In cases like this, I get your point. There's nobody saying it's not a loan. It's insane to say out loud. But my point, maybe we need to address this in a way that allows us to still exist with fees versus APR. Chair,
Mr. Chairman, maybe I can address that in part, at least. There are, again, the legislation, for example, provides an explicit exemption if an employer wants to provide these products and cover the charges, because we do see employers doing that. They recognize to retain a low-wage worker. Walmart's a good example. There are other companies like Target or Kroger that cover some of the costs, and that can also help reduce the charge to the consumer, right? Bring it below the APR, because you have to take all these costs of a loan into account, and the APR is the sort of apples to apples comparison. But there are other ways to do it. Either the employer covers the fee, which we explicitly exempt to give employers comfort so they feel better about offering these products and understand they have that protection, or like you said, the period of the loan can be longer. Right, that makes a huge difference. It's just when someone desperately needs money and they have to pay it back out of their paycheck in 2 or 3 days, that's when these dollar amounts, even though they may look small, become the high effective interest rate that you're talking about.
And even on that, because they don't really have to pay it back though, do they? Because if they don't pay it back, the only punishment is they don't get to take out another loan. There's no collection service. And I'm saying this for a very important reason, because it seems like it's necessary. And I would agree with you if they were messing up their credit or if they were chasing them down or harassing them. But the only punishment is that they don't get to take out another loan. So I'm just, again, concerned with us cutting off access to something that's clearly, necessary, because it doesn't fit in our general model of what we think loans should look like. That's kind of my concern. And I hope that this bill, the way I read the bill, it would just preclude the state from having those loans at all. And again, and that's what I want to get to, Tony. It doesn't. But tell me, what is it? So how does that make them adjust the way they do business in Maryland?
Well, they could partner with employers, as the secretary just alluded to. They could charge lower fees. Right now.
There you go. So do we have some numbers? Just as an aside, because this is obviously something we're going to be talking about. I have a member of this committee that actually put in a bill almost an opposite of this. Are there some numbers that would work for you guys? Are there some fees that would work for you guys? And you don't have to tell me now. It's just something that, are you willing to discuss the possible fees, or like you said, not calling it a loan, or what was the other thing? The tip. I think these are all things that can be direct. I just don't want to cut off something that people may need.
Sure. Well, I guess the concern is, if an employee, we've found that employees that use it once tend to use it a number of times.
Right.
So there is pain involved if you can't pay it once. There's been complaints at the FTC.
So wait, go back to that. You said there's what?
There's pain involved for the consumer, because once they get involved in this, sometimes they're going to have to reborrow.
And if they can't borrow,
it's like a payday loan, right?
I got you.
Once you get involved in that.
Except for if they can't borrow, their only punishment is they can't borrow again. So again, I really feel like we're chasing our tail. So you're saying that it's needed. And the worst thing that could happen to this person is they'll need it and not have it because they already owe, which sounds really circular when you think about it, bud. You're saying that their punishment is not to be able to take that loan out again. That's their pain. But I'm saying, but you're willing to take it away altogether to where they don't have access to it.
No. So what we're saying is this is a loan because there is the expectation that they will repay.
Without a doubt. I'm not saying I'm saying we broaden our definition of what a loan is. I'm not worried about what we call it. We can call it chicken if you'd like.
Correct.
I'm worried about it not being something. about it not being a viable, necessary entity that we now take out of Maryland because of our definitions. And I just want to make sure, even by your definition, the only pain they'll get is they won't be able to use a service that they need. But by logic, it's because they need the service.
Well, what I think you might find happening is that the companies that rely on tips and things like that, voluntary gratuities, have trouble making profits. And so the way that they would do that is by raising fees over time.
And there's where we get back to the whole fees thing and putting a cap on the fee. Oh, we're tracking, buddy.
I think we're
Secretary.
And Mr. Chairman, yeah, I might say, you know, the way these are paid back, the person gives access to their bank account, right? And so you can pull down directly, or you can pull down for the person's paycheck. I think we understand these products are going to continue to evolve, and absolutely we see a need, and that's part of the, you know, the charge this committee has given us as a department and Office of Financial Regulation is to make sure that that kind of innovation and those products can be offered, but they need to be within the guardrails where people aren't charged, you know, predatory fees. And I think, you know, there is a clear corridor of, you know, amount of fees that people can be charged and that would comply with our interest caps in Maryland. You know, question for the companies about whether that's enough for them, and you can ask them that. But I do want to emphasize, we don't know that. We hear, oh, we never go after the money. You know, we just won't lend to you again. We won't bother. But I think that may not always be true. Different models will evolve. If someone has direct access to draw down on your account, you don't know, you might get stuck with an overdraft fee from that. So I think that's the importance of keeping things in the regulatory framework, so people are licensed, so they're registered, so we know what they're doing, so we know that the way these things are not marketed falsely to consumers. So all those protections are important. It's not just the fee.
Yeah, I don't think anybody's disputing the fact that this needs to be regulated and there needs to be proper oversight. I just want to make sure that we understand that this is also something that's necessary, that we need to find a way to make it to where it's viable in the state, not just shut it down. So I appreciate.
We think that is not, we understand people need them. Probably over 100,000 Marylanders are using them right now.
Yes.
So we need to help people
Thank you
access
very
their
much.
money.
So I don't want to drag this hearing out, but I just want to make sure for everybody else to get ready to testify, you understand we may have covered some ground that you don't need to cover again. Hopefully, don't get up here to try and make your money. You can make your money by staying down or saying me too. But I think, do we have any questions? Of course. Go ahead, Adrian.
All right, thank you so much, Mr. Chairman, and thank you, Madam Secretary, for being here. I think the chairman covered a lot, so I won't cover a lot. But I have two quick questions because this is important to folks in Prince George's County. Specifically, one, has the Department of Labor actually done an assessment on what the impact will be to end users of the product if this bill were to pass? If you look at the unfavorable positions, it makes it seem like this will affect a lot of Marylanders, especially those in Prince George's County who are using this. So have there been other states that have done this and have elevated the standard like we're trying to do here in Maryland? And has the Department of Labor actually done an assessment on what that would mean for the end user of this product?
I'll start and turn it to my colleagues to complete. You know, this is a national debate. It's not just happening in Maryland, but I think it's very important for us to, you know, uphold the standards we have in the state. There are other states that have already started along this path. California and Connecticut are already, you know, looking at similar measures and putting them in place. I would say, you know, we see that, and we believe that the products will continue to evolve, right? Like, I sort of feel like this is sort of like artificial intelligence, other kinds of innovation. Technology can do a lot of different things and can enable a lot of different things. It's our job to sort of set the guidelines, and innovation can happen within those protective guidelines. I feel confident that it will continue to be products. They'll just find other ways of pricing them and offering them.
Okay. And second question, and then I will end my questioning here. You talked about overdraft fee as a potential for kind of getting their money back in cases where you can't really go after credit. Do we have any particular cases in Maryland that the Department of Labor knows about in which consumers have been overdrafted in some significant way? No.
There we go. Very good. Yeah, our staff has looked through the complaints at the FTC, and there are a number of those. So we'd be happy to
chat
identify
offline.
that
Thank you.
if we need to.
Thank you, Madam Secretary and the panel for joining us. So I have a really Delegate Barfo and the chair kind of covered a lot of the questions I had as well. But I had one particular question. You mentioned the tip component of this, and you talked about it in the context of if a tip is going to a company, then it's not really a tip to an individual. But I want to get your thoughts. There's a lot of companies out there in the loan business in regards to peer-to-peer loan systems. Is that a situation where the tip would still be applicable? Because there's programs out there where you're allowed, where there's a facilitator that joins two people together to do some type of loan service. So if you're giving a tip to the peer, to the actual person, would that still be in violation of this law as drafted?
I believe we can confirm with the Attorney General's office, but I believe that would be the case. Peer-to-peer is also regulated under our statutes, so there are limits as to what individuals can make, because after a certain point, I think the logic is you're no longer just a peer lender, you are making a business of lending. So there are limits there. And so I believe, yes, the way the amendment is drafted, it would prohibit seeking a tip in connection with any credit transaction.
But based on what you said earlier, that if the individual is being benefited from the tip, I'm trying to understand how that would apply to your definition previously. I was confused in this new definition. It's very, you just gave a definition that kind of, I'm just trying to understand how that would apply here. If the individuals are lending to each other, if that, doesn't that still fall under the idea of a tip going to the individual?
It would.
So it would, so then wouldn't that make it not
It would make it
the intent of your law, or the intent of the legislation?
that's the amendment, right?
Okay.
So the legislation there, but I think it would treat it consistently, right? So if you're just dealing, with one or two, whatever the limit are on individual loans, that's one thing. But once you start putting in a tip, it's incentivizing based on a different mindset. Let's put it that way. It's a service mindset, not a giving mindset.
Okay, thank you.
Mr. Salazar, Delegate Queen.
Thank you, Mr. Chairman. Thank you all for coming in. I know we've had lots of conversations about this bill, but I want to just get some clarifying information for my notes so that we can go forward. So Secretary mentioned that there were other types of the product. You have the employer could pay it, and then you have things where I guess there's zero fees and stuff like that. Can you tell me right now what you're outlining is? So if it's zero fees, you're not doing any regulation on it. Is that the case?
I mean, products would still have to register. Is that my correct understanding,
Correct.
right? But you don't need to there's a specific exemption for a license. And of course, you would fall within the guidelines of Maryland's consumer protection.
Okay, so they just register and they don't need a license.
Correct.
Okay. If the employee is paying it all or part, how is that handled?
Employee,
Employer.
employer
The
or
employer is the one who's going to pay.
employer, or if the employer's, there's no fee to the employee, it's not registered.
They don't
not
have to do
regulated.
anything at
That's
all. Even if they're doing only parts of it though, the employee's paying part.
If the employee has to pay a fee, then it's required to.
And so who's going to register in that case, the Walmart or the company? Because they're going to pay part of it and the employee's going to pay part. So you're saying yes, company's going to have to
Company's
register.
gonna do it.
They're going to have to register and be licensed or just
Just
register?
register if they're working through an employer.
Okay, so they would have to
So
be registered.
The only ones that would need to be licensed would be the independent third-party
The
companies
third
that are
party's
not
only
associated
licensed.
with an
Okay.
employer. Correct.
And so what is the limit? I would consider this similar to a collateral loan because your salary is the collateral, because you know you should be getting paid back. What is our limit APR for that? A collateral loan, do we know?
We have kind of a tiered loan
Okay.
if it's based on certificate of deposit or other things. So typically the limit is 33%, but there
33 is
there
the
are that's
other
the
tiers.
for consumer, and then depending on the type of collateral. I mean, arguably in this case, if if, that's what you're saying, it ought to be very low.
Should be very
because-
low. I agree.
Right? I mean, because in theory, the money's going to go into the account and they're going to be able to sweep it
Right.
out.
It's low risk. It's a low risk one, right? Okay, and so then the other pieces would be the fee types. Like I know in mortgages, you got originator fee, you got broker fees. Do we have limits on those as well, I'm assuming?
Yes. Mhm.
And so if we did some sort of fee structure, it might fit into that and we'd have to look at those limits.
You'd have to look at the limits. That's right.
And that's what the bill currently says. Does it account for fees in the current bill?
It does not have any separate, it says that they need to fit in within the current consumer loan fees. But
Okay.
you'd be opening the door to a number, any one of a number of products coming in, and other payday
But other
lenders
products are gonna
have
come in.
come in, trying to seek exemptions or their own standards. and
Right.
We would rather not have that.
I agree, but I think the point is, we're gonna have these products and we need to figure out how we set up some guidance and guardrails or some standard around that. So that's what I think we need to.
But
And we have legislators who are bringing opposite bills, so we are going to have this conversation.
Well, ultimately, it is a legislative decision. I mean, represent the Financial Protection Agency, and so, we do that. And also just point out that treating these products as loans would be consistent with the recent issuance by the CFPB.
Right,
So
I
at
agree.
a
They are
federal
loans. They
level,
are loans. They are loans. They're collateral loans in my mind. Okay, thank you.
Do we have any data on the tips, or is that part of what this bill is trying to get at?
That between 60 and 70% of for the providers that offer a tip option, 60 to 70% of those consumers will pay the tip.
Okay, and then do we have any number, like on average, it's X dollars?
What our data shows that the average fee for these loans, so the average loan is about $100, the advance that they get on their next paycheck. The average fee that's charged for that is about $3 to $4. The tip is generally in that area too, and oftentimes the tip is, as Chair Wilson said, it comes up automatically. There's an app. You're saying my payday is next Wednesday. I want $100. There'll be a for the companies that follow the tip model, there'll be a suggested tip amount.
Okay, can you walk me through, I would be interested just going back and maybe having something, well, I guess this would ban it with the amendment tips, but I would be interested in what, drilling down data a little bit more narrowly on that front. But it was alluded to, if someone doesn't pay, they don't go to collections. So what happens if someone doesn't pay? They just can't get another one of these? That's it?
That's correct. So one of the features of this that's different from the other payday loans that came before this, all these kind of advanced access to your paycheck have evolved. So for this variation, there's not an accruing amount. If you, for some reason, don't pay the money back, it's set up automatically where on your payday, you're going to pay them back. If for some reason, and there's a 97%, there's only a 3% default rate from the industry is what they've shared with us. And even then, that 3% is going to cure their amount that they owe because they want to use the product again. So for the amount, sorry, what was your question again? So that you want to know the 97%, there's 97%.
Like so let's say I front my paycheck. Can I get a free paycheck out of this?
No. So the way it works is when you want access to money before your payday. So next Wednesday is your payday. You're only 4 days into this week. You want to borrow $100 against it. What they're going to do, what the models will do is look at the amount of days that you've worked so far. You can't get 50% of your full paycheck. They're going to say, well, you've worked 4 days so far. Most of the models will say you can access 2 days worth of your pay. So 50% of what you've worked so far. You go on your app, you make the transaction. It's $100 plus there's a $3 fee. If it's a model that says a tip, there's a mechanism for you to adjust the amount of the tip. The amount's deposited into your account. In that transaction, you're granting access to your bank account. so that automatically when your paycheck is direct deposited, it's the lender can draw that money back plus the amount, the fee that you agreed to. And so that's it. So it's a very low risk product for the lender because it's secured by your paycheck.
Gotcha. Okay. And so I guess the last is the bills, in my opinion, just reading through it, all the expectation here is that we treat this as a loan. And that's
Correct.
all you're asking for the protections.
Because when you make that transaction, when you agree to the amount that you're paying, what we do is we'll look at these transactions and say, for this amount, $100, for this $3 or $4, whatever it is, the standard that the General Assembly has set up for us to evaluate all loans in Maryland is APR. So we calculate that APR and we say, this product is far above the limit that's set by the state. So what we're saying is, because it's a loan, because it should be regulated by the state, it's got to comply with lending laws.
Okay. So there's an amount
Including the
borrowed.
rate cap.
There's an amount borrowed. There's an expectation of repayment.
Right.
And we're just basically trying to have regulations around the interest, which would be the third criteria for a loan.
Right.
Okay. Thank you.
Thank you, Mr. Chair. I just wanted to go back to a comment that Delegate Adams made a little while ago and build on what you just said. The comment, I think, was along the lines of the fact that, you know, you would expect a higher interest rate if it's a riskier loan. And so even within that, I think we want to make sure that we are protecting people, even if they are a riskier loan. But it sounds like this is about the least risk loan that you could possibly engage in if you have access to the bank account and you have access to the paycheck and the pay has already been earned. So even if somebody were to be let go the very next day, they have access to that money. I mean, so I'm even trying to figure out the 3% who default. How does that even happen?
I mean, they've described, the industry has described scenarios where maybe what someone could do is they take the loan and then they quit the job, or they take some dramatic steps to detach their direct deposit from their bank account before that's deposited into the account, you know, and so they avoid paying that money. But the industry will not go after that person, so there's no recourse. And I think it's not financially, it's not enough money. There's small transactions, so that they know that, you know, they'll just if that person wants to work with them again, they'll have to cure that debt, and then
Okay.
they can resume using the service.
But with the logic of the safest
Right.
loans ought to have the lowest interest rate, one would think these would easily fit within Maryland's interest rate caps.
Sure, other Maryland lenders who are nearing that cap of 33% might be factoring in a high risk consumer who they're justifying charging that high interest rate for. This is a very low risk consumer because it's guaranteed by their paycheck.
So it seemed reasonable to
And
have.
so, and yet the fee, when we calculate it using APR, which is the standard that we're, you know,
You have to
required
translate it to
use,
something.
we translate it into something. We say this loan is, you know, 100 to 400% interest, depending on what the fee is.
Okay. There's a question I want to ask, and I'll say it out loud and then I won't wait for an answer. Because I don't think my chair would like me to actually ask the secretary to answer the rest of this question. But my question for the secretary and for everyone to consider is, it's been said that we need this service because so many people are living paycheck to paycheck. And so we're not trying to run them out of the state. We're just trying to make sure we're protecting people. And I agree with that at this moment in time, but I'm just wondering if you might outline all the things we might do in the state so we wouldn't need this service. And so people wouldn't have to live paycheck to paycheck. But you can get back to me another time
I will.
on the answer to that question.
Happy to.
Thank you. Thank you for your brief question. And thank you for your very short non-answer. I believe Delegate Aaron, I don't know if you forgot your question. You good? Outstanding. Okay, guys, again, thank you very much for your presentation at this point. Now, please, again, for all the remaining people I call, please realize what's been covered, and you're not going to do your side any favors by just kicking a dead dog. So the next, we'll start with Tammy Bresnan, Marceline White, Ricard Jones, Lauren Sanders.
Good afternoon, Mr. Chair and members of the House Economic Matters Committee. My name is Tammy Bresnahan. I'm the Director of Advocacy for AARP Maryland. You heard from the Secretary of Aging. I'll make 2 points. There is a rather large population of older people working because the three-legged stool no longer exists. That includes pensions. They only have Social Security, and if they have a supplemental savings because they are working. AARP has a long history of a history against payday lending loans, and we just want to make sure that if such a product exists, that the constituency is protected. We believe that regulators should eliminate unfair, deceptive, and abusive practices, and we ask you for a favorable report with amendments on House Bill 246. Thank you.
Good afternoon, Chair Wilson and members of the committee. My name is Ricard Jones. I'm the political director of 1199 SEIU. We are the largest healthcare union in the country with over 10,000 members in hospitals, long-term care settings in the state. We're here today because we strongly support this bill as a measure to protect low-income workers, many who are women, women of color. We have worked very diligently to advocate for minimum wage increases over the years. Again, thank you so much to this committee for its work last session to accelerate the minimum wage to $15 an hour. But as you know, often 15 is not enough, and workers look to small short-term loans like these products to cover everyday expenses for food, transportation, housing, and utility payments. It's important for us that we continue to protect low-wage workers' paychecks from lenders that encourage short-term borrowing practices that end up trapping consumers long-term. We've already heard how expensive these products are, and they're used frequently by workers who are struggling to make ends meet in fast food, retail, healthcare, and they're in this cycle that it's a never-ending cycle where they are forced to rely on these services to meet basic needs. We realize that the fees make it really difficult for a borrower to see the true cost of the service, and this is having devastating effects on workers who never see their full pay and fall further behind. We do understand that this product can be a benefit, but we do believe that we should level the playing field and make it clear that any advance that comes with a cost is a loan that must comply with Maryland's interest rate limits. And for these reasons, we urge a favorable report. Thank you.
Good afternoon, Chair, members of the committee. My name is Marceline White. I'm the Executive Director of Economic Action Maryland. Economic Action Maryland works on economic rights and equity through research, education, housing justice, and direct service. And we are here in support of HB 246. I want to thank the Commissioner for bringing this bill. And as I talked about previously, Maryland has a long and strong history of keeping high-cost loans out of the state. We believe this provides clarity and guidance in the law at a time when complicated products are flooding the market. This simply says that a loan is a loan, and it clarifies what constitutes a loan. If I borrow even against myself for a future advance against my own earnings, it is a loan, and particularly if I use another provider and pay a fee or a tip. That's simply what it does. And then it allows the regulator to put some guardrails around and treat it like any other loan and level the playing field for other lenders in the state so that there is a level playing field. I just want to provide a couple quick points. As my colleague said, we know that low-wage workers are struggling, and I think this is a long-term structural issue. We appreciate all the work that's happened in terms of raising the minimum wage, but it's still not enough, which is why people are struggling because they can't make ends meet, and they're borrowing against themselves to try to make ends meet from payday to payday. And so what that means is that you create a cycle where you're churning your loans and you're borrowing against yourself. So what you see and what the research has shown is that people will borrow 33 to 100 times. And if you're paying those fees, even if they're small, they add up over time. If you're borrowing 33 to 100 times against yourself and paying those fees. So for these reasons, we ask you to support this legislation. Thank you.
Chairman Wilson and members of the committee, I'm Lauren Saunders, Associate Director of the National Consumer Law Center, a nonprofit organization that works for economic justice for vulnerable consumers, and we are pleased to support HB 246. California collected data on nearly 6 million earned wage advances and found that the average APR is 330% for both tip-based and employer-based advances. Those rates matter because California found workers take an average of 36 loans a year and as many as 100. And this cycle means they are really just borrowing to fill the hole in their paycheck and not getting new liquidity. California also found that companies use multiple strategies to make tips almost as certain as required fees, and about 73% of tip-based transactions carried tips. HB 246 is consistent with longstanding loan definitions across the country and recent laws or proposals in Connecticut, California, and Washington. The CFPB recently stated that earned wage advances share fundamental similarities with payday lending products. And remember, payday loans got their start by arguing that their small check cashing fees were not interest. The bill would allow employers and third parties to offer free wage advances, as many already do, including through these services. Others would simply have to comply with the cost limits that other cash advances follow, whether they call it a fee, interest, or a tip. Low-wage workers in industries like fast food and retail, where workers are disproportionately communities of color, should not face high fees for wage advances that just make them pay to be paid. These loans should follow Maryland law. Thank you for the opportunity to testify. I urge your support.
Thank you. Ricardo, I have a question. I was trying to wrap because your reaction was my reaction when I first heard about this. And as far as the scheme itself. And I had to take myself back to my Army days where I was making $635 a month when I wasn't deployed, and how, we were kind of looking for ways to make ends meet. So my concern, again, that you've heard, is that we, by one way or another, make that where this industry is not allowed in Maryland. So they talked about the 330% being a high interest rate, but I mean, I'm not good at math, but it looks like when you charge me $3.50 on a $100 loan that I have to pay back in 2 days, that's probably what they're talking about. Do you think that $3, and do you think that's is that too much to be paying for a $100 loan?
Yeah, absolutely. I think that's too much when most workers are a few dollars struggling just to pay BG&E, buy groceries. So
Sure.
$5, an additional $10 could take you from not being able to pay one bill or not being able to get your child to daycare. So I think those fees, they could be too much, but they also need to be transparent. You need to know the true cost of the loan.
Without a doubt. I don't think anybody here is disputing the weird tip thing that I understand is off-putting. And I think, no disclosure is very, very, my concern really does rely on that we do something to where they're like, we can't afford to do business in Maryland. And then all these people, my daughter's a CNA, so I think she belongs to y'all. And believe me, whatever the minimum wage is, that's what they're paying them,
Right.
And so there are times when even she would need to rely on something for getting her dog to the vet.
Yeah.
She knows she's got the money, but she just can't access it now. And I'm just troubled because I know if you make it something like 25 cents as much you could charge, which may fit our model, then they're going to say, yeah, that's not worth setting up the computer system, especially when I have no guarantee of collecting. And so I just want to know, I don't know what that magical number is, but I know that we have to move away from APRs just on the sheer fact that most folks don't understand what they are anyway. People get messed over on that. I just want to know, because I know your workers, they work hard, and a lot of them are very much minimum wage workers. And you would agree that this is something that we need to try and find a way to make work, right?
Yeah, I mean,
And I'm not trying to put you on the spot. I just know you have an opinion.
No, it's fine. I mean, I would love to work to raise wages so that we don't need these services. That's I think where we should start from there. But I do think, I don't think the legislation is trying to remove these companies. I think it's trying to make it more transparent so that when you do if you do have an emergency, that you know exactly the true cost of the product. So that's why we're here today.
But the legislation does basically set such what would be considered by these circumstances, the APR rate makes it almost untenable. The cap that we have makes it untenable for these loans to exist in the state. And that's my concern. That if we go ahead with the APR rates that have been suggested, that would make it untenable to do business. No business would want to do that. So we'll talk offline about that, though.
Okay.
Thank you. Are there any other questions? Chris?
Thank you. So it's a $100 transaction and the consumer pays $3.50. I don't understand how that's deceptive. I think it's transparent. Would you agree? Anybody that would wish to answer the question in the panel?
You know, they're structured in various different ways. There can be the basic fee, there can be an expedite fee. Obviously, the tip adds up. And of course, it's the way these things add up that is especially not transparent. A single
So-
transaction may be, but over time, the cost.
Let me
is-
restate my question. I need $100. And before I get $100, somewhere somebody's going to say to me, here's your cost of borrowing that $100 for the 4 or 5 days. That's the product. Is that correct?
Again, the fee structures are different depending on the company.
Even if the fee was $15 to borrow $100, the point of the question is about this concern with transparency. The debate here is not transparency. It's that you want to have it fit within the context of a interest rate. So I'll ask the question,
Yeah.
and I don't want to belabor, please don't take this as me belaboring you. I'm just speaking to the idea that if there is $100 I need to borrow, I'd like to know what it's going to cost for me to borrow the $100. And I firmly believe that this product, whatever it looks like, whatever the fee structure is, will be known to me before I click a button on my app, on my phone, and borrow the money. And is that not correct?
I think that's probably normally correct.
That's
Federal
all.
law does require APR
Okay.
disclosures if the fee is
That's-
over
that-
$5.
You answered my question. Thank you.
And I guess last, just when I go to ATM, it's not my bank, they charge a fee. That's my money that I have access to. I have to pay, and if depending on where you go, it's $250. And that's why I'm just concerned with, literally, when I go to ATM outside of my bank, they charge a fee. So I'm trying to wrap my head around something where, and that's not a loan, that's just my money. And they have to know before I can get my money, that I've got money. So they're not, that's a no risk at all. That's no risk. They're just taking my money, and it's convenient, and they've said it in a way that it's convenient for me, and I need it in order to get my haircut. So that's where, I don't understand. I know where we're going, and I hope we're all going the same direction, but fees aren't, we deal with fees every day. They're it's like the cost of doing business. That's why I can't wrap my mind around how this has gone so off the rails. I understand our intent, but to say because it's $350, that's an exorbitant fee when I pay $250 or $2 or $150 for my own money. And that's what I don't really understand. And I that's maybe not a question, but would you agree that we do pay ATM fees?
We do pay ATM fees, and I think, similarly, right, you are paying in this model to borrow against yourself, right? You're paying fees to borrow your own money, right? And we can argue the fees, but I think at the heart, taking the 10,000-foot view, what this bill is doing is it a loan? That's the fundamental question. Is it a loan? And if we agree it's a loan, then is it regulated like like a loan in Maryland? Because we have ways that we regulate we regulate loans in Maryland by the commissioner, and that follow along certain laws in our state. And I think, kind of the fundamental question is, if I borrow my own money and I pay fees, is it a loan? And that's
I see your
the
point.
products, the models, whatever we can
It's just when it's a loan, for some reason, it's now villainized. But when it's my ATM fee on my money, we don't mind if I go to the casino and get hit with $250 every time I go. And I'm just concerned with, again, the way this is being twisted, especially if we can clean it up. And because I see a lot of people on here giving to testify about not wanting people to be victimized. But as the good delegate said, if we make them where they're apparent, there is going to be a cost. If there's a cost for me to draw my money out, there is probably going to be a cost for somebody to take a risk that I still have money. And so I would assume, we want to call it fees, whatever you want to call it, it's a cost from my convenience, like the ATM fee. And we seem so offended by this, like we're taking advantage of people. I'm like, yeah, go get your haircut. Go to a gas station. They get you all the time. I don't hear anybody testifying against that.
Well, I mean, I think there have been other bills in this committee around those kinds of fees, obviously. But I think the issue to me, and why I'm up here, is we have a whole body of legislation around how we treat loan products. And we want, if this is a loan, then we want it to fall within the ambit of how we regulate loans. Because that has certain enforcement and certain investigative powers and certain kinds of ways that it's regulated. That doesn't mean that it's better or worse. That's up to the commissioner. That's up to this body to determine what kinds of fees and transparency and, you know, certain kinds of regulations. But if we think it needs to be regulated like a loan, then it's even to the playing field for all the other lenders that come before the state. And that's part of, you know, the issue too, because we have all kinds of other consumer loans. So, you know, do we treat them the same way or not? I think that's part of that issue. You know, there are other issues too, but I think that's fundamentally what part of this is.
I appreciate your answer. I think you gave some wonderful answers. Is there any other questions? I think you guys, have we had everybody up here? Did I miss somebody? You look ready to read, ma'am.
I already testified, but I'd be happy to.
No. Appreciate you. You're taking up enough of everyone's time today, so thank you. It says here Donna Edwards, but I'm gonna go with that's Delegate Weibel's relative. Thank you. We have Reverend Kobe Little, Mr. Schneiderman, Wilson Meeks, go ahead, sir.
To avoid retreading well-trodden ground, Brian Weibel, Maryland State and DC AFL-CIO. We have already heard many of the concerns listed here today. We come forward with a very simple kind of principle around this, is that workers should not have to pay fees in order to access their pay. We understand that these are products that many workers use, and that clearly, due to the conversation of the committee, many workers are relying on these because of low pay and high cost of living. We understand that, we recognize that, but we agree and echo the previous points that many others have raised, that if these are lending products, they should be regulated as such. And to add to that, the true cost of any loan is ultimately going to be viewed through APR. So it might be the case that some people do not see a way to make it financially viable if they're not able to charge these equivalent fees of 300% APR or such things like that. And that is why we emphasize again that the bill does nothing around the ability of employers to partner with these companies or provide them in their own way to give basically wage advances to their employees as a benefit. And as such, we think the ultimate solution to this question is obvious: higher wages, more frequent pay. But if we are not going to be able to get that within this hearing, we stand by the fact that it is a product that needs to be regulated, and the true cost of any loan is going to be viewed through APR.
Good afternoon. My name is Bill Meeks. I'm the Assistant Attorney General in the Consumer Protection Division of the Maryland Attorney General's Office. It's the division's position that under existing Maryland law, direct-to-consumer EWA companies already are lenders, but their advances are loans, and that the fees that they charge are interest and subject to Maryland's usury laws, and the companies are subject to Maryland's licensing requirements. CBD supports the bill because it confirms that Maryland law applies to direct-to-consumer EWA providers. This is important partly because these loans and the companies that provide them target low-income, financially vulnerable consumers. Compensation models are opaque and confusing. With all the fees and charges, the cumulative APR, including tipping models, is often an average of over 330%. Comparison, Maryland's interest rate, usury rate for these types of loans, 33%. To be clear, this is not the first time that companies have tried to circumvent Maryland lending laws by calling themselves something other than lenders, and their fees and their interest charges something other than interest charges. It's been happening for hundreds of years. These are payday lenders by another name. The division supports amending the bill to ban lenders from asking for or accepting so-called tips. This is inherently misleading. These fees are not a tip, they're finance charges. One of the delegates before had mentioned that finance charges should be based on market conditions and risks. That is not what a tip is. A tip implies something totally different. Traditionally, and that may not be the case now, tips have been used in circumstances of you give your waiter a tip for an individualized service, The money goes to your waiter. It's associated with generosity. If you don't do it, it's rude. I understand the commissioner has frustration that tips are being used to mask price increases. The same is here. If you want to charge a finance charge, you should call it a finance charge. The concept of using tips to increase prices for things should not be normalized, especially in the context of lending. This is a regulated industry. There's usury caps, price increases, and other.
Thank you, Chairman Wilson, members of the committee for the opportunity to testify. My name is Franz Schneiderman. I'm a consumer advocate and work with a group called Consumer Auto Maryland that works to protect Maryland consumers and Maryland drivers. I just want to add my voice to the folks who point out that these are lending instruments that impose significant costs, mostly on low-wage workers, because they mostly go to low-wage people who need the money to pay their bills. And because of the way money is withdrawn from the next paycheck, it creates a cycle where they often take them out many, many times. So the seemingly small fees add up to a considerable burden for low-income people, which is why I do think it's important that the state act to regulate it, these fees, and treat it in the way we do other kinds of payday lending. It's an important protection for low-income workers. It's consistent with the state's longstanding commitment to protecting Marylanders against predatory lending and payday lending. So I think that's important, and I hope you folks will look favorably on the bill. And I think, as Delegate Charkoudian pointed out, these are relatively low risk transactions for the lenders because, after all, they're secured by their coming paychecks. So it seems to me that the fintech community ought to be able to find ways to work within the state's APR and other regulations to make these products available. Thank you.
Good afternoon, Mr. Chairman and members of the committee. I'm the Reverend Kobe Little, and I'm president of the Maryland NAACP. It's good to see you, Mr. Chairman, and it's good to see Delegate Fennell and Drs. Charkoudian and Queen and the members of the Legislative Black Caucus. I'm grateful to Secretary Wu and the administration for offering this legislation. I have submitted written testimony on behalf of the NAACP, and I hope that you'll take the opportunity to peruse that testimony. It has the data that the committee likes to see. I'd like to use my time here today to frame this issue. This is a democracy issue. This is an economic justice issue. This is an economic security issue. There is no more American value than democracy. Economic exploitation is the antithesis of democracy. In order for democracy to flourish and to thrive, there must be economic justice, there must be economic security, and there must be economic opportunity. The good news about this bill, Mr. Chairman, is that you don't need to know math. You just need to know right from wrong. And it is wrong to exploit people who receive low wages. The government has the responsibility not to put earned wage access out of business. This legislation doesn't do that. But it does regulate the industry, and that's what's important. It is important for us to understand, as I've said, that economic exploitation is the antithesis of democracy. We hate what happened on January 6th. We can do something about it by passing House Bill 246. Slavery is economic exploitation. Redlining is economic exploitation. Wage theft is economic exploitation. Pay disparity is economic exploitation. And onerous fees and the idea that earned wage access industry needs tips is ludicrous. Please, we urge your favorable consideration of this legislation. Thank you.
Thank you. I'm looking around. I see no questions for this group. So thank you guys very much.
Thank you.
I think we do have a virtual.
Thank you.
Ms. Monica Burks, you're online. And make sure I would remind anybody who's listening, if you're going to be testifying virtually, to make sure you turn off your YouTube when you're Zooming, so you don't get confused. Yes, ma'am, we see you, we hear you.
Good afternoon. My name is Monica Burks. I'm Policy Counsel with the Center for Responsible Lending, a research-based organization that's dedicated to eliminating wealth disparities in our society. I've been grateful to hear the conversation here today, and I won't repeat much of what has already been covered, but I think it's important to, one, acknowledge that the fees that we are using as examples, something in the range of $3 to $3.50, is not an accurate picture of what people are paying to access money using these lenders. The expedite fees alone, which says you can get your money within 30 minutes versus 1 to 2 business days, those in and of themselves range from $1 to $4. The mass majority of users pay expedite fees because they need the money before they get to the next payday. So those fees are almost a given for most users. There's transaction fees, which also range from $1 to $4, and it only costs the lenders about 5 cents to send money to conduct these transactions. And then there are tips. And regardless of whether or not it's appropriate to ask for tips, 40% of the company who uses tips in their model, 40% of their multi-million-dollar revenue comes from tips from low-wage workers who are accessing these loans to make it to the next payday, to put gas in their car, to put food on the table. And most of the time, these tips can represent a significant portion of a person's pay. And if you look at the materials that we submitted with our written testimony, you can see the behavioral psychology used to compel users to tip. They will guilt users and say, hey, you didn't tip last time. We recommend you tip $6 this time. And it also makes it seem like if you tip, you're paying it forward and you'll actually be benefiting individuals. As a matter of fact, there's a screenshot in our policy paper that says if you tip, you'll be helping 3 people, which is not. Thank you. That was fast 2 minutes. But
I'll give you a few seconds to wrap it up, ma'am.
thank you. So I just want to say that the reason why I'm here is because we, people who use these products, including people from my background, people who look like me, we never get a chance to negotiate the terms of these transactions. And we are putting we're giving that leverage and that power to the Attorney General, to the Department of Labor, to bodies that are watching these markets and understand how they work and can see the patterns and see the impact. And so giving them the authority to regulate what they in the way that they deem appropriate is the only opportunity that low-wage workers will have in this context to access these products on reasonable, responsible terms. And so that is why CRL is in support of this legislation. Thank you for your time.
Thank you very much. Seeing no questions, we'll go to our other person online, Pete Iceberg. He's a last virtual. No. Sir, I don't know if you've been muted for some time, but your audio is still, it says your audio is still connected. Maybe you can't hear me either. This will be brief. Sir, can you hear me? Can you hear me? No? All right. I don't feel we have a good connection. I do know we have a multitude of other people.
I'm sorry, I did just connect. I'm sorry. I had technical problems.
Yes, sir. Yeah, we watched you talk, but we couldn't hear you. If there's any way you could make it brief, I want to give you time to talk, but we really, we've got to keep this moving.
Thank you. Make one quick point. I serve as president of the National Payroll Reporting Consortium, which is a trade association of the largest payroll service companies in the country, which collectively cover about 1/2 of the U.S. workforce. The suggestion we have for the bill is that the bill should be amended to clarify that payroll service providers are not required to register as an EWA service provider. We serve really to facilitate EWA services by verifying available earnings. The registration reporting obligations would result in many payroll firms declining to facilitate EWA services, making them unavailable. They wouldn't work without a connection to payroll systems. I'll suggest as a model, the California Department of Financial Protection and Innovation issued regulations governing EWA services with an exemption for payroll firms that serve in this limited facilitation role. So I would offer and suggest adopting California's language, which I can send separately. So I'll leave it at that. Open to questions. Thank you.
Thank you very much, sir. I see no questions, and thank you for your input. I'm sure you have written testimony as well. Thank you very much. And I believe that concludes the favorables to this bill. So we now have the unfavorables. We're going to start with panel one: Frank Boston, Ben LaRocco, Roger Mano, Molly Jones. All right. Thank you, Reverend Little.
Ready? Yep.
Guys, please go.
Yeah, Mr. Chairman, members of the committee, I'm Frank Boston III. I'm here on behalf of Earn N and representing Ben LaRocco to my right of me today, and we respectfully oppose this bill. I think the committee will see the more rational and reasonable bills, and I hope all of the same people who supported the bills today will support our bill for licensing and regulation. The main issue here is that this product is not a loan. It is an advance of money that you have already earned. There's no term, no interest rate, in fact, no interest at all, no recourse if the consumer does not pay. We don't report to the credit agencies. It's not a loan, but a new and innovative product that thousands of Marylanders use. In fact, 73,000 Marylanders use our product alone, and we're just one of many companies. There's an old saying: if it ain't a duck, don't look like a duck, don't quack like a duck, then it's not a duck. We're not alone. It's an advance of money that you already have, and it's a new and inventive product. The committee should know who uses this product. Businesses such as Home Depot, Walmart, Amazon, all of their employees, not all of their employees, but their employees use the product a lot. School systems and teachers use this product. Baltimore County school system, Baltimore City school system, Prince George's County school system, Montgomery County school systems, all use the product. Medical systems use the product. In fact, Johns Hopkins University employees all use the product. As you can see, this product is popular in this state. We urge this committee to reject this bill, and we look forward to working with the committee on common sense legislation. Thank you.
Thanks, Mr. Chairman. Thanks to the committee for allowing us the time to speak today. Hopefully, we'll get asked some of the questions too. I think there were a lot of questions that, quite frankly, were better to answer than maybe some of the previous folks on the specifics of how the product works. But I just want to say, Earnin, as Frank mentioned, we have about 73,000 customers, wide ranging across the state.
Two states that were also mentioned that did something similar I want to talk about a little bit. California has proposed that it would be a loan, but they have modified that regulation in a way that would still allow us to operate. So it's pretty different than what's being proposed here. Connecticut did do something similar, and we had to leave Connecticut. So we left Connecticut at the end of December. We just got some data back from our customers in Connecticut, and our Connecticut customers got 10% more overdrafts so far in January than similarly situated customers in Massachusetts. So basically, when they lost this product, they're getting more overdrafts. So much higher products, 10, 12 times the cost of this product. One other thing I want to make sure I talk about is the fee structure. Everybody has the option to use this product for free. There's a free option for all the providers. They only opt into payments for expediting fees if they want. My company does ask for tips. I expect I will probably get some questions on that. I'm happy to talk about that. But it's not like we're asking for a tip on top of another fee like a restaurant would or something else. The tip allows people to choose a price and support us if they want, and that aligns incentives. Most financial services, maybe not most is not the right word, but a lot of financial services. All right, I only have 10 seconds left. I look forward to your questions. Yield back my time.
Thank you, Mr. Chairman, members of the committee. Roger Mano on behalf of Pay Active. Mr. Chairman, we approached the legislature during the summer to put in legislation to regulate this industry. We actually support a different approach than this bill. We're supporting legislation being authored by Delegate Fraser Hidalgo and Senator Klossmeyer. And our intention is to make sure that Maryland remain a safe space for workers and for consumers, to put some guardrails in place so that EWA providers actually register with the Commissioner of Financial Regulation, that they be bonded, that they remain non-recourse, that there are no overdraft fees, compounded interest, credit card checks or reporting, or any predatory or deceptive practices. Then this product can live up to its intent, which is to actually promote financial wellness and to end payday lenders and predatory practices. So for those reasons, I would just like to say, as a former member of this committee, I think it's important that we get this right. It's an important issue. And we look forward to working with the committee to do that. And we respectfully ask for an unfavorable report.
Thank you, Chair Wilson, Vice Chair Crosby, and members of the committee. For the record, my name is Molly Jones, and I'm the head of public policy at Pay Active. We are a financial wellness company that has been offering earned wage access services as an employee benefit in Maryland for nearly 10 years. Despite claims made earlier, we have no complaints from Maryland residents in the CFPB database. Thank you for the opportunity to testify. I very much appreciate your attention to this very new and very nuanced issue. I am here respectfully testifying as opposed, as the bill would adversely impact the hundreds of employers that offer EWA to thousands of Maryland workers. EWA is a relatively new payroll innovation. It allows you to access your pay as you earn it without having to wait for payday. If you're someone living paycheck to paycheck, this is a lifeline. Consumers do not view this product as a loan, and numerous third-party reports have verified this. There were a number of inaccurate claims about how EWA works, which is concerning when we're talking about regulating an industry in the setting. It's important to note that employers themselves reach out to Pay Active to offer this service as a benefit to their employees. We integrate into their payroll systems and use verified time and attendance payroll to make their own earned wages available. This is not an anticipated paycheck. This is earned income. We offer 5 free ways for users to access their earned wages and 1 paid option for premium services. This paid option has a nominal flat fee to instantly transfer wages to any bank account, offsetting the cost that the provider incurs to make that transfer. This service is optional. Our users also have an option to access their wages instantly for free to our debit card. There is no cost to the user for using this card, despite the claims made earlier, and all of these fees are clearly disclosed to the user. The bill before you today is incongruent with how the industry operates. We've proposed an alternative framework, and we look forward to discussing it with you. Thank you.
Thank you, Chair. So the gentleman next to Frank, you're gonna get your wish. I'm gonna ask some questions.
Great.
Your product is free. Is that what you just articulated to the committee?
Yeah, anybody can access it at no cost.
All right, and so when we've heard all the anger and frustration over tips, you also are the one that does the tip. Is that correct?
Correct.
And if I'm a consumer and I needed $100 and I wasn't being charged a fee, your business model is assuming that my good nature would say, well, that's worth something. And I don't know what that might be worth to me, but it may be worth something more than nothing. Is that generally your?
Correct. So yeah, so how I think there was one question about sort of stats around, maybe it was Vice Chair Crosby. So some people tip most of the time, some people tip never, some people tip sometimes and not other times.
Mm-hmm.
Our average tip is like $1.35. So you know, it's usually like $1 or $2 and it gets to that average of about $1.35.
Okay.
I can pause there.
No, you can pause there, right? Because I think you answered the question. So I mean, look, I'm a business owner. I don't use your company or anybody when somebody needs money from me as an employee. I give them the money and give them the time they need to pay the money back. I can tell you they're appreciative. I don't think they want to give me any more money than what they're borrowing, but I think they do it when they need it. I think they appreciate the fact that it's available. And I would think that if the committee was being pragmatic about this particular issue, our position should not be one of how can we make things difficult through regulation, but rather how can we make this work within the context of your business model? Because two things: one, it's needed. We've already had that testimony, but two, you're doing it for free.
Yeah. So
that's a rhetorical. I'm just saying to you that, yeah, I really am thankful that you shared the testimony because we spent an hour here listening about tips. All right. And
if you provide that service without registering with OFR first, you could be in violation if this bill passes as written as a small business owner.
Yeah.
So just one flaw potentially in the legislation.
Doug Charkoudian.
So are you all for-profit companies?
Yes.
And you do pretty well? What you make-
We're a B Corp, so profit is not our only goal, but yes.
Okay, and the others, are any of you nonprofits?
We're a C
grant
Corp.
funded? Okay, so presumably you come into this planning to make money, right? So even if it's free, there's got to be a business model that you believe is going to earn money. Is that right?
Yep.
Okay, so in that sense, if you're dependent on tips in your case, you've got some kind of a business model that has people wanting to give tips. I've seen some of the examples of what that looks like and pressures people. So there is a model that is about, I'm going to give you your money before you get your paycheck, and I am going to earn money on that. Is that right? Would that be fair to say? You're giving me money before I get my paycheck and somehow you're earning money off of that,
Correct.
whether it's tips or fees or whatever that mix is.
Correct.
Okay. So how is that not a loan?
You want to take this one?
So we partner with employers, we integrate into the payroll system. So we know how we get a daily census file. So we know if you're working, and we get verified time and attendance payroll data. So we know how much you've already earned. Back in the day, you used to go, work on a factory or a farm. You get your wages at the end of the day and you leave. It was really only since payroll was automated into a batch service that you get paid every 2 weeks. So this really helps the worker access those wages that only have been earned.
Yeah, I don't disagree that there's potentially a value to having money sooner for all the economic injustice reasons that we've discussed about exploitation of low-wage workers. What I'm trying to understand is how we should regulate, right? Because you all have said you have another bill that is a regulatory bill. You just like it better than this one. So I'm just trying to understand how I understand how payroll works. I understand that people need their money when they need it. And I'm trying to understand what the best way is to regulate that to make sure that people aren't exploited, either explicitly and directly or psychologically because they're paying tips that they think is helping somebody when really it's, profit to your companies, which is fine. There's no problem with for-profit companies. I'm just saying to pretend like it's helping somebody else when someone's paying a tip seems somewhat problematic.
Sure. So yeah, so I can address.
But can I just come back to, because my question was not how does payroll work? My question actually was, if you're giving me money in advance of when I'm going to have access to it, and then you're earning money off of giving me that money, how is that not a loan? That's really what my question is.
I'm happy to address that. So I think that part of the reason that we're here is that as this is a new product, that it is a little bit ambiguous. So we are advancing money and we are getting repaid, and that is very loan-like. But we do not have many of the other things that are part of loans. There's no requirement to repay. There is no interest. There's no credit reporting, either as an underwriting or reporting on the way back if you don't get paid. The way this industry, sort of the first regulation that ever happened on this industry, was the CFPB put out a payday rule back in 2017. This was under Director Richard Cordray, who's appointed by Obama. It specifically exempted EWA and direct consumer advances in that rule. And it said, if you meet certain criteria, you are exempted from this rule. You are not a loan. You are not a pay loan under this rule. So the way that the industry has evolved is based on that criteria. We've added a lot of new criteria. The bill that will be hopefully considered later is based on a law that was passed by the state of Nevada last year, supermajority Democrat state, that provides a lot of consumer protections and differentiates between what makes it specifically in the loan bucket and what allows it to be in a different bucket.
So was it just, thank you for that. You were talking about the Consumer Financial Protection Bureau?
Correct.
Okay, but they have so you mentioned 2017. It looks like in 2020, they established a new set of guidelines that said, if you're going to have an EWA program, it ought to have these 7 characteristics. Specifically, the employee makes no payment, voluntary or otherwise, to access advances.
Yeah.
So that voluntary or otherwise seems to be the piece that has to, and the provider does not solicit or accept tips.
Yeah.
So actually embedded in the guidance, they do allow for the nominal processing fee for that payment. So
okay, and I get nervous when folks come in and reference federal agencies and recommendations and then give us a set of recommendations from 8 years ago when there's one that's more recent.
Let's talk about it a little bit. So that is a non-binding advisory opinion.
And
it is,
guys.
Sorry.
We definitely don't want to get into a discussion that can be had offline because we have other people to.
Can I ask one more?
No. Oh, yes.
Can I ask one more question? I just want to make sure we have the accurate information about what the federal body is saying right now. But my final question is this. I think part of the confusion and part of what makes it slippery and hard to figure out how to regulate, well, it's not hard for me, but part of what we're struggling with as a committee in these questions is that there's so many different types of fees. So I just spent the last half hour as this was going on trying to see if I wanted to access this, which product would I go for? I've been to 5 different websites. I cannot figure out there's one that has an enrollment fee, but the enrollment fee can be waived if I have some special code. So do they all have enrollment fees? Do some of them have enrollment fees? There's some that are free, some that have a first time fee, some that seem to have a expedited fee, which if I need the money today, I need the money today. It's not going to help me to get in 3 days. Some that have the tips, some that have other fees that I can't even, but I can't find any of that on the websites. So my request to you, if you want to build trust as we're figuring out how should we regulate this, is if you could each articulate, like in a matrix, here's all the fees that any company could possibly have, and here's the ones that each of our companies have. And it's possible that some people would access it and not have to spend all those fees, but it's really not transparent right now. And it would be helpful to see that kind of a matrix.
Sure. So we don't charge an activation fee of the companies that have been participating in this industry.
You don't need to tell me all right now. I can see some of them right here. So I'm just asking for that would be helpful for us to see if we're going to figure out what is the right way to regulate this. Thank you, Mr. Chair.
Okay, so Frank, so if I loaned you my pen, you give it back, that's a loan, right? And that's my point. We don't need to get tripped up on whether this is a loan or not, because I think most folks are here going to be like, man, it's a loan. Just because you don't charge interest, that doesn't make it not a loan. Right. That's not the point. And please don't get wrapped around that versus the importance of this service. Yeah. I wanted to actually talk more with you guys about something that sounded like it was going to be taken off the table, but maybe you have a defense, was the tips. Now, and because I've heard a lot about the fees, which again, and I compared that to my transaction fees at the ATM, and I'm still paying that same amount. I haven't heard a bill yet about that. Definitely not from the Department of Labor or anybody. And so now we're talking about tips, and I kind of explain about all the tips I'll pay within the next few days if I go shopping anywhere. Any kind of food source that I get, I will be asked to provide a tip. So what I want to go back to is what you were saying. You laid out a model, and I think your problem is we're not going to presume that every one of these lenders, or you don't want to call yourself lenders, whatever, have this model. But you're saying that for you, they can do this for free, correct?
Yeah, every provider that is earned wage access and not something else needs to provide at least one free option to access the funds.
And I think it's because I just overall, having been here all these years, I find it ironic, especially because we're one of the only countries that are a tip culture. That every time I come here, every bill I hear is about promoting that tip culture and giving workers more money. And now we're saying that tip culture is evil because it sounds like everything I heard before, that has to go. And I guess it just flies in the face of logic of what, especially if you're providing what could be considered a free service.
Yeah, I think that it aligns incentives. Customers only pay us if we reward them, or if their service is so good that they want to reward us with a voluntary tip. And they get to choose
Would it
what
be
they
a
want to pay or
problem
not.
if the default amount was zero?
I think, look, we want to serve the people of Maryland in a sustainable way, and anything that is on the table in order to do that, I think is worth discussing.
Again, but from your professional and your business side, I appreciate you trying to work with us. Would it be a problem because I don't have that on any of the places I'll go shopping in the next 3 days, but would it be a problem if the default was zero and you had to press the plus button to get to an amount?
I think that's absolutely worth discussing further with the committee and understanding the implications of it. I don't know. I'm sorry. I don't know.
Bad answer. Okay,
I know. I'm sorry.
I was trying to give you a softball there. The point was, I was very adverse to the tips, but then I realized when you are providing a free service, plus every other bill I'm going to get in here is about the importance of tips and making sure people get tipped whether they make $15 or $30 now. So that being said, I wanted to make sure that because that does seem like an issue that threw a lot of people off when they first heard it, myself included, that you're paying tips on top of paying. But again,
yeah, I'll be back to you with more on that. My apologies for not having a better answer for
Thank
you. Thank you, sir.
I think that just speaks broadly to the importance of creating a regulatory framework like the one that passed in Nevada, created a number of very stringent fee protections as well as disclosures, including around tips.
Well, I mean, we're definitely gonna do something like that. But Delegate Chief, your light's been on for a while.
Thank you, Mr. Chair. I've been patiently waiting. Stop laughing. Mr. Boston, you mentioned in your testimony, and I'm trying to clarify my understanding, which is you rattled off a long name of employers, organizations, private and public schools across many different counties that use this system. Are you talking about employees working for those institutions? Or are you talking about those employers that step in to address this issue and offer that service to their employees?
And I'll turn it over to Ben after I answer, but Delegate Chief, both. So under some models, there's a relationship with the employer, and the employer allows us to access the money through the employees. For example, us with Home Depot. Others have relationships with Walmart and other companies. But with the school systems, we're talking about the employees. A lot of those employees, there's no, at least not with our company, there's no defined relationship with the school systems. But a lot of teachers and school system employees and employees of the medical University of Hopkins University's medical systems use our products individually.
Yeah, so
the data just shows that.
Yeah, sorry. When we downloaded a list of the employers of our users in Maryland, and so those names that Frank said were all the top 10 employers of our users. So it's not directly with like Prince George's County Public Schools, but the teachers are using us.
Okay.
But maybe you should explain Home Depot.
Yeah, we do have a partnership with some businesses like Home Depot and others.
Okay. And I think in listening to my colleagues' questions, I was also wondering why in any case would you not want to charge anything? Because if you are a for-profit business, you are in the business to make a profit, right? Otherwise you would be calling yourself a nonprofit. So I'm very interested in this B Corp thing. What made you get into that? Because if you are in the for-profit business, then there has to be some way for your risk calculation to be able to stay in business. So I don't know why you would ever want to not charge something, but then ask people for tips. So I just don't understand.
Yeah, thank you. Yeah, that's a great question. So PayActive is a B Corp corporation. You're correct. We were founded literally to kill the payday lending industry and provide an alternative. It's a very mission-driven company, and we make revenue off of two ways, and that's how we can charge the free option. The first is that instant transfer fee to any bank account for $3.49, flat fee, no interest, et cetera. We also have a debit card that is completely free to the user or the employee. They can get their wages direct deposited onto that card for free. So they can instantly access their earned wages for free. And so we make money or revenue rather off of the interchange when they use that card, like many fintech companies. So that's how we're able to offer the free option.
Here, Frank, let me. So our CEO started.
Wait, guys,
Okay.
we're getting to a long conversation, some which most likely could be had off record. So I would like to roll this up real quick because we have other witnesses and we have an event tonight. So I want to make sure everybody's well rested before we get there. Frank,
Yep, I just want to make something
better be
really clear so the
amazing.
committee doesn't feel like we're being disingenuous. Our company, chips is not the only way we make money. We also make money on, basically if you want it immediately.
We
I
understand
just
that.
don't
Yeah,
want
that was the expedited fee was explained to us. So we do understand
I
that.
just want to make sure
that if they wanted expedited, that's basically how you make your money. Okay, seeing no other questions, Steve, thank you. You're amazing. We're gonna go on to our next panel.
Thank you.
We have Ray Napples and Phil Goldfeder, as well as Elaine Combs. And I believe that's all the in-person that we have. You guys would go ahead?
Great. Good afternoon. I'm Ryan Naples and I'm from Daily Pay, one of several EWA providers that operate in the state, and we're the largest EWA company in the country. So we've done business in Maryland since 2015, and we oppose House Bill 246. Currently in Maryland, more than 62,000 employees have used Daily Pay, and over 490 businesses in state have offered our service to their workers. A few things about EWA we can say generally. So you've heard before, EWA is based on wages earned, so workers can only access their own money they've already worked for. We're not providing credit or a loan on future wages not yet earned. Because we're not lenders, no EWA provider, and we can talk generally, charges interest or late fees or considers creditworthiness for any purpose. So that's another reason how we're different from loans. EWA products are also non-recourse. If an employer, in our case, fails to make payroll, the risk is on the EWA provider, not the worker. We don't go after the employee if the employer goes out of business. While there are usually some small costs associated with EWA, as people have heard, at least one no-cost option is both offered by most EWA providers, but also is a requirement in the bill that we've been talking about as an alternative. A nominal fee of about $3 for instant delivery to any bank account is also common and also never based on creditworthiness. And it's a no-cost instant delivery option is also becoming more and more common in this industry. There are 0 employers who offer EWA for free aside for Walmart. There's been a lot of talk about how this exists. It doesn't. We try very hard to get employers to cover the cost, the instant cost. It happened more during the time of COVID. We can usually get about half of our employers to cover about 50 cents. We also have research that shows that we save people money. That's why people use us. We're not solving for an income insufficiency problem. We solve for a frequency of pay problem. We have data that shows how we do not trap people in cycles of debt, and we track our high frequency users. I know I have 5 seconds left. Awesome. So we would ask for an unfavorable report. Thank you so much. More things to come. Yeah. Go for it.
Thank you so much for the opportunity to testify today. My name is Alon Sean Calms. I'm a Director of State and Local Public Policy for Chamber of Progress. Chamber of Progress is a left of center tech industry coalition that promotes technology's progressive future. We have a number of corporate partners that include companies like Daily Pay and Chime, but our partners don't get a vote or veto over any of our positions or statements. Today, I'm here to urge an unfavorable report on HB 246 for many of the same reasons you heard on the previous panel. We are concerned that this bill could stop many earned wage access products from being offered in the state. We are broadly supportive of earned wage access because of how helpful it can be to workers when bills are due or when there are emergencies. A 2021 study by FTI Consulting of 4,000 EWA users found that about 45% of users would choose not to pay essential bills if this product was unavailable, or deliberately overdraft, or instead use a payday loan. We feel that EWA helps make sure workers don't have to turn to more risky options like payday loans or credit cards. This helps ensure that consumers don't end up in a trapped in a cycle of debt. We have some recommendations we'd like to make when it comes to regulating EWA. First, we would encourage the committee not to prefer an employer-based model versus a direct-to-consumer model or vice versa. Employer integrated models allow employees to receive their paychecks earlier directly from their employer, whereas direct-to-consumer models allow a third-party service provider to provide funds to the consumer without direct involvement from the employer. Second, we'd like to again note that EWA differs from traditional lending. This service traditionally does not pull from credit reports and does not impact credit scores. Thank you so much for your time.
Thank you, Mr. Chairman. My name is Phil Goldfeder. I'm the CEO of the American FinTech Council. We count all the companies that testify today as our members. I want to be very, very clear about something that I spoke about earlier. Responsible, innovative financial services companies stepped up to serve this country when every big bank in the country walked away. Community branches and bank branches are closing at the fastest clip in history, and FinTech, responsible innovators, continue to fill that void. And so everybody you heard today testify in support of this spoke of APR, right? This tired old idea of APR as the one true way to measure what this costs. And as the chairman rightfully pointed out, most people have no idea what APR means or how long it's going to take to pay back. How often have we gone into a department store and they say, oh, do you want to save 15% on your bill today by signing up for a credit card? And you don't know what the terms are, and you don't know what the conditions are, and you don't know when you have to pay it back. We're offering a transparent, clear product. And you think about it, and I think the chairman talked about $2.50 for a fee. I know I paid $5.99 for an ATM fee to take out $20 just a few days ago, and no one questions the idea. Earned wage access is a fair product, and this bill, unfortunately, is the easy way out. It's the easy way out because we're trying to not be creative about understanding the nuances of a new product. We're trying to shoehorn it into an existing model that we think may possibly could help, but unfortunately, it's going to do quite the opposite. And so I think a lot of the questions were directed in the right way, and I thank the chairman for sort of pointing out a lot of the issues. And I just want to finally say that why is it that we talk about the companies have the right to this money? Congressional staffers get paid once a month. Why don't we question that? Why are we not finding more ways to get our employees the money they need? These companies stepped up while so many big companies have not, and they shouldn't be penalized for that. We should find ways to help encourage the regulation in the right way.
I do not see any questions, so I will move on to our virtual guys. Just be patient. Alice Jacobson.
In the right way, and I thank the chairman for sort of pointing out a lot of the issues, and I just want to find.
You have to turn off your YouTube, sir, otherwise it'll be caught behind.
Well, good. Hey, I'm Matt Pierce. I'm the founder and CEO of Immediate. Thank you for the opportunity to be here today and speak. I don't want to belabor a point. We've heard a lot of conversation from the rest of the people who have shared today. I, for one, have actually enjoyed hearing the opinions from the other side, because I think it just makes us better as organizations, as FinTech organizations. And so really what I want to say, as opposed to just saying me too, as you shared earlier, I would just like to point out that I think it's important that we continue to have this dialogue, that we continue to have a dialogue with the committee to make sure that earned wage access is viewed and regulated as its own financial product versus being lumped in with some of the others. When you look at some of the things that we do, specifically Immediate as an organization, similar to Pay Active and Daily Pay and some of the others who have shared today, we are only delivered as an employer solution, right? The employer offers this as a voluntary benefit, and we're typically seeing 25 to 30% of employees that will enroll. And then those users who make transactions, those employees, we're being reimbursed as part of a standard payroll deduction. So we're not going into their bank account and pulling money out. We're actually getting paid back by the employer. And so I think that's one thing that as you look at this, there's a lot of different flavors of earned wage access, financial wellness, but we just want to make sure that we have an opportunity to sit down and discuss with the committee how we each differentiate. And so we thank you for that opportunity to do that.
Thank you. Seeing no questions, move on to our next virtual. Is that Alice Jacobson? You can go ahead, ma'am.
And so we thank you for that opportunity to do that.
Thank you. Seeing no questions. Ma'am, you can go ahead.
Thank you very much. I appreciate the time. My name is Alice Jacobson. I am the Director of Government Relations for Payroll.org. We're a nonprofit organization representing payroll professionals. I'm not going to beat the dead horse, as it's been said, on identifying earned wage access not as a loan. I just wanted to make one comment, which is that I think what we're struggling with here is that we're trying to take new technology that wasn't considered when we created the financial loan laws, and that what we need to do is to step outside of that box to look at what the technology does and doesn't do, and to create an appropriate set of regulations that will do what we need it to do for consumer protections, such as the full transparency that we talked about. Our approach in government relations at Payroll.org is to work with government, not to fight government. And so I will open that door to working with all of you as we move forward. Thank you very much. I appreciate your time today.
Thank you very much, ma'am. Seeing no questions, we'll move on to our next. Is Garth Adam? You can go.
Okay, perfect. Good morning or good afternoon. I guess it depends on where you are. I'm actually, it's morning for me right now, but thank you for the opportunity to provide testimony today. My name is Garth McAdam. I'm the General Counsel for Zayzoon. Zayzoon's an employer integrated provider. Currently, we work with over 250 small to mid-sized businesses in Maryland, and some of these have as few as 10 employees. So these are businesses that are trying to compete for talent against companies like Walmart. JP Morgan research shows that 50% of small businesses are operating with fewer than 15 days cash buffer. And I think that this is often underappreciated when we talk or suggest that it should just be pushed onto the employers to fund these advances or to pay for them. So this concern about cash flow and being paycheck to paycheck applies to businesses as well. And the data shows that this is especially prevalent for businesses in Black and Hispanic communities. So these businesses are often simply unable to fund EWA, which is why services like ours are required. So I do believe that the ATM fees, I won't get into that, but I do believe that that's the perfect analogy for what EWA is. So instead of in both cases, the consumer is simply accessing their own money, whether it's held in a bank account or being held by their employer. It's the exact same thing. So I do also want to stress that this bill, as drafted, will significantly and immediately shut down access to EWA for tens of thousands of Maryland workers. Should this bill pass, many responsible EWA providers, including Zayzoon, will be required to reduce or entirely stop our services in Maryland. And this is just as it's currently happening in Connecticut. So thank you all very much for your time. I really do appreciate the opportunity, but respectfully ask for an unfavorable report on this bill. Thank you.
Thank you very much. Seeing no questions, I believe that brings us to our last witness, Brian Tate.
Mr. Chairman, can you hear me? If you can hear me, good afternoon, Mr. Chairman and members of the committee. My name is Brian Tate. I am the president and CEO of the Innovative Payments Association. Our members include a number of companies who are part of the value chain, which makes EWA available to the public, a number of whom have testified today. I want to let the committee know I'm here to express my support for EWA and the IPA's willingness to work with you and your members of the committee because we share the committee's goal of protecting consumers and permitting EWA providers to operate in the state of Maryland. I won't rehash a lot of the conversation that's already taken place, but I will say the vast majority of